Good morning, everybody. I'm Professor Paul Daly from the University of Ottawa, broadcasting, as you can see, from the Rideau Canal on the traditional lands of the Algonquin people. And it's my pleasure to welcome you all to this event, Vavilov's first birthday. Where I should acknowledge the help of the Centre for Public Law in setting this up, and also the support of the Alex Trebek Forum for Dialogue. I suppose the late great Mr. Trebek might have asked someone, what is Vavilov? And today, that's what we're going to have our dialogue about. A year ago, in a landmark decision, the Supreme Court of Canada completely reoriented Canadian administrative law. And 1,500 decisions later and countless changes to procedures before administrative tribunals and other decision makers, we're here to take stock of what Vavilov did, whether it achieved its purposes, and what its effects are proving to be. We have three panels. The first panel will be a general overview of Vavilov, how we got there, where we're going to go next. The second panel will drill down into some specific areas of substantive law, such as immigration and environment law, to discern the effects that Vavilov has had. And the last panel, we will hear from various people with expertise in the front lines of administration and the judiciary on how Vavilov is being applied in practice, what sort of a difference it makes. On the first panel, as I say, we're going to look at what led up to Vavilov, what the Supreme Court was trying to achieve, and have a preliminary view of whether they did manage to achieve it. And I suppose I would highlight two things in that regard. First, in the years leading up to Vavilov, the decade roughly between the Supreme Court's decision in Dunsmuir in New Brunswick in 2008 and Vavilov in 2019, there had crept into Canadian administrative law a significant degree of confusion and uncertainty, particularly around the selection of the standard of review, an old staple of Canadian administrative law: correctness, reasonableness, patent unreasonableness. And one which had become rather confused and uncertain in the decade prior to Vavilov. Moreover, the application of the reasonableness standard, which had come to characterize much of Canadian administrative law, was shrouded in some uncertainty. The Supreme Court had not given much guidance on what reasonableness means, or what methodology reviewing courts should apply to discern whether a decision is reasonable or unreasonable. And this is all complicated by the fact that on the Supreme Court and in the Canadian legal community generally, there is fairly profound disagreement about some fundamental issues. And I would pick two in particular. There are some judges and some lawyers who like rules. They like categories, they like bright lines, and the certainty that they think it brings. There are others, however, who are skeptical of the utility of forms and categories and rules, and prefer standards and contextual assessments. And that split is evident on the Supreme Court and is evident in the Canadian legal community generally. In addition, there is significant disagreement about whether there is any role for deference to administrative decision makers on questions of law. There are many who say that the role of the courts is to provide authoritative interpretations of the law, and that deference is heretical. And, however, there is another group, well represented in the Canadian legal community, which thinks that on some issues, at least, administrative decision makers with their expertise and experience and specialized knowledge have an advantage over generalist judges, particularly in technical areas of regulation. So that's the setting for Vavilov, and that's the background to Vavilov. And I'm joined on the first panel by several panelists who have participated in one way or another in the formation of Vavilov and the formation of Canadian administrative law. I'm very pleased, honoured indeed, to welcome David Mullen, Professor Emeritus of Law at Queen's University. And David, if I could start with you, you've been around the block in administrative law terms. You were there at the birth of modern Canadian administrative law in the 1970s. In the run-up to Vavilov, how confident were you that the Supreme Court would achieve its goals of eliminating uncertainty and providing some clarity about the reasonableness standard?
Paul, thank you very much for the invitation to be part of this panel. I think one of the things that has always struck me about Vavilov is that these are very unusual proceedings in which the Supreme Court asks for submissions on the nature of the judicial review of administrative action as addressed in Dunsmuir, with particular reference to the standard of review. What exactly were they getting at when they directed the parties in the development of their factor to address these issues? Nature and scope of judicial review of administrative action, that suggests that the mandate was going to be a very broad one. But then it gets limited somewhat by as addressed in Dunsmuir. Does that confine what is going on in terms of the making of submissions to the court to the kinds of issues that were raised in Dunsmuir, to the exclusion of administrative law, judicial review principles generally, and then the reference to, with particular reference to the standard of review. In basically preparing for today, I thought about this from the perspective of Alexander Foley, aka Vavilov, and how he might have taken the directions that the Supreme Court of Canada issued. And I've constructed a very short, but I think revealing dialogue between Vavilov and his lawyer, which I'll just go through. It'll take a couple of minutes. Lawyer contacts Vavilov, presumably somewhere in Moscow or traveling in Europe on his Russian passport. And the lawyer says to Vavilov, "I've got some good news for you. The Supreme Court of Canada has granted leave to the government to appeal the Federal Court of Appeal decision in your favor. They've also decided that this would be a great case in which to reassess some of the general principles of Canadian administrative law and judicial review of administrative action in particular. They've therefore linked the appeal in your case with another case involving advertising during the Super Bowl. And they've appointed a couple of friends who are going to help them resolve all of these issues. And also there's going to be a lot of interveners who are going to be allowed in as well, whose primary interest, quite frankly, is not in your case, but in judicial review of administrative action generally." Vavilov to lawyer, how can that be good news? Under the existing law, I won in the Federal Court of Appeal, courtesy of a judgment by one of Canada's premier judicial review of administrative action judges. And now I feel as though my victory is going to be exposed. This in itself looks to me as though the court is turning itself into a mini legislature. Why am I being victimized in that particular way? Lawyer to Vavilov, whichever way it goes, you will take your place in the pantheon of administrative law litigants, alongside not just Roncarelli, Nicholson, Baker, but even surpassing in fame the mighty Dunsmuir. There will be conferences galore named after you. Every administrative law scholar of note will be writing about your case. Generations of law students will frequently cite you, whether they know what it is or not. And of course, judges all over the country will feel obliged to cite Dunsmuir in every judicial review of administrative action proceedings. And to cap it all off, the redoubtable Daly will be giving you a first birthday party. So be grateful, accept what's going to go on, and maybe you'll win anyway. And I hope this dialogue that I've constructed illustrates what, for me, was one of the problems going into Vavilov and the Bell Canada decision. The question of, is this an appropriate role for the Canadian Supreme Court to play in terms of trying to sort out what they regard as problems with judicial review of administrative action? Was I confident that the Supreme Court of Canada was going to achieve its purposes? That assumed, I think, or the question assumes, that I was confident in identifying what the purposes of the Supreme Court of Canada actually were. I think Paul Daly has said in introducing the panel that there were a number of things that were obviously points of tension between the Supreme Court, within the Supreme Court of Canada going into Vavilov. Just to take a couple of examples, obviously the concept of jurisdiction was under real threat. The question of the contextual evaluation of the evaluation of contextual factors for establishing a standard of review was under consideration, and whether or not it should be replaced by, and indeed effectively had been replaced by, presumptions and also categories. In other words, there were a lot of things that were going on in the Supreme Court that suggested that the Supreme Court wanted clarity on certain issues and they couldn't agree on how to get it. And also, in addition, I think there was a sense in which judicial review of administrative action needed to be simplified, whatever that might mean in these contexts. So was I confident? I wasn't confident, nor was I lacking in confidence. I was just interested. Thank you.
As we all were, frantically refreshing the page on a year ago on the Supreme Court's website to see when it would come and what would come. Of course, before, we should say we didn't even know that Vavilov was going to be the one, did we? There were a couple of cases. There's the Bell Canada case as well, but in the end, it was Vavilov where they put all of the weight. I also have in the room Professor Sheila Wildman from the Sulik School of Law out in Dalhousie. Good morning, Sheila. So I wanted to ask you again, setting the frame for Vavilov, to talk about the variety of administrative action that the Supreme Court was setting itself up to address. It was trying to maybe simplify, as Professor Mullen says, but simplify what exactly? We traditionally associate, or at least in the origins of Canadian administrative law, we were concerned with labour tribunals and other administrative tribunals. But over the years, of course, judicial review has come to be extended to all sorts of different forms of decision making. So can you provide us some context perhaps, and how, and again, what were your feelings leading up to Vavilov as to how the Supreme Court was going to go about its work and whether it was going to be successful?
Sure, thanks, Paul, and thanks for involving me. I've also kind of framed these opening remarks with some reflections on Vavilov and its implications, or its potential, maybe the anticipation around Vavilov, on the part of advocacy organizations representing what we might call the vulnerable, or persons vulnerable to excesses of state power. So just to back up, I'm standing today speaking to you from a very snowy landscape here in Mi'kma'ki, which is the ancient and unceded territory of the Mi'kmaq. My own thinking and writing about the reasonableness standard in particular, around the standards of review over the years, has tended to, really center on, you might say, one question, which I think is the same question that the court's jurisprudence has centered on, veering to one side and the other as it goes, which is really, how is it possible to reconcile the two central imperatives of judicial review? And those are, at least in one way of slicing it, the imperative of deference on the one side, of course, and the imperative of justification on the other side. And we keep asking that question around, reconciling these two imperatives in different ways, at different times, in different administrative contexts, as you say, and yet, at the highest level of principled doctrinal guidance or attempting to achieve that. And I think we keep asking it, with these resets that we've seen over the last 40 years, every 10 years, because there is no simple answer. So I'm glad that you opened that question up to me around, the many administrative contexts that are affected and implicated in the Vavilov decision, but also in that question around implications for the vulnerable. And I'll put that in sort of quotes because that too is a very complex and diverse and challenging territory. But it reminds me of why I became interested in administrative law in the first place. So what led me to this area of work and study wasn't a kind of, a systems theory or institutional theory or sort of abstract ideal of good government or even the rule of law. It was a concern for what I understood to be voices that were profoundly discounted or suppressed in state systems. And that started in my own interest, just to get, biographical on it, but in my own interest, it started with determinations of legal capacity. And there, I mean, the capacity to have one's decisions or even statements recognized as expressive of legal agency. So that's one of many issues determined in Ontario at the Consent and Capacity Board, just one of the many, sort of capillaries of the administrative state that are affected by principles like those set out in Vavilov. So others here today, over the course of the day, are going to address in some detail more of what you put to me in terms of the diversity, the array of decisions and decision-making contexts that are implicated in the Vavilov decision. And these, of course, defy easy summary. And they defy, really, it's challenging at least, to apply to them a common set of principles. So we're talking about a range from municipalities making bylaws to environmental regulators, potentially compiling, evaluating thousands of pages of evidence before making recommendations or deciding on highly controversial projects, to human rights tribunals, making rulings on discrimination, and so on and so on. So there are a range of different processes, interests, and consequences always in play. And that, of course, makes this project of articulating coherent, responsive principles really challenging. I try to start my course on administrative law in a way that reminds people of all these far-flung sites, right, at which administrative power registers in people's lives, and registers over time in ways that we can understand to come to express deep structural patterns of domination and exclusion. So in my class, we start with excerpts from James Daschuk's book, Clearing the Plains. And that, gives a sense of the harsh realities of executive decision-making at the founding of the Canadian administrative state. So the willingness to use starvation and other coercive measures to move Indigenous communities off the rail corridor and onto less favorable lands. So we think in my class about how that story contrasts with the stories that we usually tell about the administrative state, all this range of diverse agencies and decision makers attempting to bind the nation, through these essential processes of social coordination across this array of complex fields. And I try to remind the students, and that's, I guess, what I'm doing now as we start these really important conversations about Vavilov, that the administrative state is both a force of, social welfarism, an effort to fashion and apply regulatory instruments in pursuit of the public good, and it's a vehicle of domination, of exclusion, of silencing, of suffering. And so it's really important for us, I think, to center this question of Vavilov's implications for the vulnerable or those vulnerable to state power. More positively put, we could talk about Vavilov and social justice. So just to close off my opening statements here, I had in mind a kind of way of situating Vavilov in the lineage of, the every 10-year resets that we've seen in administrative law, which have kind of veered between labor and immigration contexts. So very different, but also very charged contexts of power relationships. And I think there's a lot to say and think about on that, but I'm not going to do it now. Just a last thing on Vavilov. itself. And maybe this contrasts a little bit to what Professor Mullen has said about the process of decision in Vavilov. So I would say that it was a standard of review, reset opportunity in which the court demonstrated what I'd call a sense of occasion. And by that, I don't just mean in its, sending invitations far and wide to folks to inform its work with multiple views into the perspectives and experiences of administrative state stakeholders, but also in the case that was picked. So Vavilov, as folks have said, was at bottom a case about the right to have rights. Hannah Arendt puts the salience of this, foundational idea, the right to have rights, into focus in her work, bringing out the fact that human rights or legal rights are not just, self-executing or inherent to the person. They require a political community, maybe an administrative state, to take effect. But that community and state has limits, and the refugee, like the person lacking legal capacity, and so the power to say yes or no recognized in law, and the person who's found their citizenship certificate revoked, that's a limit concept that tests the legitimacy or the reach of our powers of justification. So I think it was very appropriate that the occasion for this reset on the law and the standards of review happened in the context of Vavilov's case, or about the Vavilov case, where what was an issue again was revocation of the certificate of citizenship, and that served as an occasion for a quite radically participatory, now limited, of course, in all the ways that litigation is always limited, but a kind of participatory think session on the standards that should serve to structure and to limit justification in administrative law. So I'll close off there. I've taken long enough. Thanks.
Well, thank you very much for those remarks. Now, in terms of this unusual proceeding, this participatory think session, we are lucky to have one of those invited, one of the principal protagonists, Audrey Bochter from IMK Advocates in Montreal. Audrey, you were, of course, one of the amicus curiae who assisted the Supreme Court in charting a way forward for the Canadian legal community. But from what Professor Mullen and Professor Wildman have said, you faced a significant challenge in framing your submissions to the court. So how on earth does one go about framing submissions to a divided court in a divided country on issues which range over such a vast terrain?
Well, thank you very much for the invitation, and it's really a pleasure and a privilege to be here with all of you talking about this decision when you're on. It's Professor Mullen talked about the direction, or kind of the lack of direction that was given to the parties, and I would say our direction was even broader than that. It was simply the court, to assist the court by serving and filing a single factum common to all three appeals, not to exceed 40 pages. So that was kind of the extent of the direction. I guess the court followed a similar model as to the one that was followed in the Senate reference, where you kind of take an academic and a practitioner and you lock them up in a room until they come out with a 40-page factum and kind of hope for the best. So I was, of course, very lucky to be paired in this exercise with Professor Daniel Jutras, or I should say now Dr. Daniel Jutras. So, I mean, in terms of what guided us, really that overriding consideration was, how do we actually assist the court in dealing with all of these difficult issues that Professor Mullen and Professor Wilderman have identified. We saw from the decade after Dunsmuir the extent of the kind of the divisions that had resulted, but we didn't want to just talk about the 10 years since Dunsmuir. For us, it was really important to kind of go back to the very beginning. And I think as amicus, you kind of have that, you have that ability to kind of go back to the basics and start and do a little bit of the history and the foundational building blocks. And I think it's really difficult for parties to always have this job of doing everything, because we're everybody's limited in pages and everybody's limited in time, and parties, lawyers who are advocating for parties have a specific job to do, which is to advocate the position that's going to best represent the interests of their client, all the while also trying to assist the court. But as amicus, we really had the space to be able to do this from, I guess, a neutral and maybe more comprehensive perspective, even though, as Sheila says, it's, for me in particular, as an advocate, I'm usually on the side of applicant applying for judicial review and seeking to have decisions quashed. But I had to kind of put that out of my mind and really tackle this from a neutral perspective in terms of what as a framework and as principles would be the best, would best be able to help the court in going forward. When we talk about protecting the vulnerable, there really are no easy answers. I mean, what protects the vulnerable? Is it correctness on charter questions, or is it deference to human rights tribunals that might actually be more progressive at times than the courts in terms of where they are in their evaluation? So it was really to take a step back from that, try to understand how we got to this critical juncture, but also go back to the foundations that underpin judicial review, legislative intent, the rule of law, and examine what they mean. Because I think what we saw from all the debate in the jurisprudence is that if there's not a common understanding of what the pillars mean, then the house is just bound to keep falling over and over again. So trying to actually to distill down those pillars, what they mean, and then try to build it back up based on that kind of common understanding. And in our factum, we did not take the position that Dunsmuir had to completely go by the wayside and go out the window. The framework was sound. The idea of having a default rule with categories does aid in simplicity. But it was clearly going to require some adjustment if it was going to be true to the underlying principles. So, those were the goals. And then finally, to talk about the implications for reasons and reasonableness review, even though it wasn't the major part of what we spent time in the factum. I think the connection was, if we're going to, if the underlying principles are going to work, this institutional design model, if it's going to be respected and it's actually going to have legitimacy, then we need to go back to the basics of reasoned decision making and ensure that reasoned decision making kind of stays the linchpin of institutional legitimacy, whether no matter how the institution is designed, that needed to be a core principle.
Well, thank you very much. It's nice to have a view into how the sausage was produced in this particular case. Lauren Wihak is with us from McDougall Gully in Regina. Now, over the years, Lauren, you've written about administrative law, and I think it's probably. I'm not doing you an injustice, I don't think, if I suggest that you think it's important that judges have the last word on some jurisdictional issues and some issues of law. And I want to ask you whether you're happy with what came out of the Vavilov exercise, which in a sense might be viewed as a compromise between pro-deference and anti-deference judges, with the pro-deference judges getting a presumption that reasonableness is the standard of review of administrative decisions. That's the starting point. But anti-deference judges getting arguably a fairly big concession in statutory appeals, so that where there's an appeal from an administrative decision maker to a court, the appellate framework applies, the Hausen and Nicolaisen framework, where it's correctness on extricable questions of law and palpable and overriding error for everything else. Are you happy with the compromise that was hammered out? Is this what you would have arrived at if you were starting yourself from first principles?
So thanks, Paul, also for the invitation to participate today, and for that question, which has a lot of layers to it, despite its apparent simplicity. I've reflected a lot on this notion of pro-deference and anti-deference, and and first of all, whether I'm anti-deference or whether there is such a binary division. And I'm not sure there is such a binary proposition, and that you're either on one side of that question or the other. My criticism of not so much the Dunsmuir framework, but the post-Dunsmuir jurisprudence was that through that more categorical approach to standard of review, the lack of any meaningful framework for assessing reasonableness and this notion of imputed expertise, it didn't really allow for, in my case, practitioners who need to argue these things, a lot of guidance as to why in any given circumstances, a administrative decision or an exercise of statutory discretion should be allowed to stand or not. And I should say I come to this question not only from the perspective of a practitioner whose job it is to ultimately advise clients, both administrative decision makers themselves and those affected by administrative decisions, but from one who's an administrative law generalist. So I don't appear only before labor boards. I don't appear only before the competition tribunal or the copyright board. In the past year alone, I've had a file dealing with the denial of WCB benefits to a police officer for psychological injury benefits, the demotion of a principal's duties under the Education Act, a dispute as between a subset of a municipality and its governing municipality over various obligations under the Municipalities Act, on behalf of a town dealing with bylaw enforcement, and in the context of a decision maker dealing with a duty to consult. So that's just the range, speaking to Sheila's point about the range that exists. I've got my toes in a lot of those different types of decisions. And so these are nuanced issues reflecting different types of decision makers and enabling statutes. And that the reality is that there will be circumstances that might call for more or less robust review depending on the circumstances. So I have nothing wrong with this notion of deference as an overarching principle of administrative law. I don't in principle disagree with it, but without a framework to implement it, I think, which is what we were lacking prior to Vavilov, it's just a word. And I think this can be manifested in the criticism leveled at the Supreme Court, where they give lip service to the notion of deference by saying, no, it's reasonableness review, but then we're going to employ disguised correctness review and intervene in the decision in any event. So that's not deference just because they say they're applying deference. And I'll be the first person to admit there's a lot of decisions in the Canadian administrative state where courts have no business interfering. Policy and legislative decisions in particular, municipal bylaws of professional regulatory organizations, policies adopted by agencies like the Workers' Compensation Board or the Liquor and Gaming Commissions or things of that nature, where unless you've got a legitimate charter complaint, there's really that's not the role of the courts. Those are policy decisions and courts should generally stay out. But there are cases in any number of different circumstances where either because of the nature of the interests at stake or the specific nature of the decision, courts should be looking to that question of whether the deference is earned in the context of that particular exercise of statutory discretion, or to your point about statutory appeals, where the legislature itself, in creating the body, has indicated a more robust review rule on the part of the courts. And so if this sort of diversity of decision-making is properly accounted for, I think it's possible to accept that courts aren't, as a general organizing principle, too readily to interfere with or overly scrutinize administrative decision-making. I think, as a starting proposition, that's fine, while still accepting that there are cases where intervention by the courts will be warranted, either for rule of law concerns, for justification concerns, for charter concerns, or just generally to ensure that individuals subject to state action aren't subject to arbitrary or capricious decision-making. We all make mistakes, administrative decision makers included. So with that, by way of preliminary comment, I think my answer to that question is yes. To your initial question is yes. Am I happy with the compromise that the court arrived at? And it's not because I think it allows the courts to be, generally speaking, more interventionist than before, but it's because we have a framework now. to meaningfully determine whether that deference has been earned in any given case. And from a client's perspective, it's much easier now for me to give advice about the prospects of a judicial review application, the imposition of some more robust reasoning obligations on administrative decision makers, I think will also help those affected by those decisions to, even if they're bad, come to grips with them, because there's that transparency that wasn't necessarily required before. But ultimately, both lawyers and reviewing courts now have this framework in which they can argue and assess whether that deference is warranted in any particular case. And so not only will administrative decision making be more transparent, one hopes, but judicial review will be as well, as the courts will now have a framework in which they have to justify their decision to intervene in the decision, and they can't just sort of, depending on how they got dressed in the morning, decide whether the decision should be quashed or not. So ultimately, I think whether you're pro-intervention or not, what we now have is more guidance and a more principled approach to dealing with these questions, which are not going to be the same for every given decision maker that one might face in the administrative state.
So skipping ahead, Sheila mentioned that there's a 10-year cycle in Canadian administrative law. The famous every 10 years we get a New Brunswick liquor or a Pushpanathan or a Dunsmuir or now a Vavilov. From what you're saying, it seems like you think we might not have to go back for a do-over in 10 years' time.
Well, I would never pretend to say that. But I think, the beauty of the common law and how the common law is intended to evolve is that there's an ability certainly to tinker. I mean, the list of factors that will give indicia of a reasonable decision are certainly not exhaustive, and they're open to reevaluation if more factors need to be added, other factors need to be altered, etc. And again, I'm speaking from the perspective of a practitioner who likes the guidance that a framework like this provides. And there's certainly an opportunity for counsel to make incremental submissions as to why that framework should be altered in other ways, perhaps without having to revisit the whole thing.
Thank you. Thank you very much. Professor Mary Liston is also with us, up very early in Vancouver at the Allard School of Law at the University of British Columbia. Lauren mentioned the common law, Mary, and I'm going to run with that and ask you to place Vavilov in its broad historical context. Is one of the issues which in the origin story of Canadian administrative law, it was hostile common law judges who were hostile to the administrative state and sought to narrowly read progressive legislation and crimp the work of administrative tribunals, which led to the emergence of deference as a key core concept in Canadian administrative law. It was a reaction against the old hostility of the common law. Are you as sanguine, as optimistic about the future of Canadian administrative law after Vavilov, or do you fear that to some extent those bad old days before the origin story began are back with us?
Thanks, Paul. Thanks for inviting me, and thanks for the question. As Paul says, I'm coming from the West Coast. I am on unceded Coast Salish lands, and in particular, I'm on unceded Musqueam Territory lands. I suspect that Paul wanted me to play the role of Frank Costanza, that this is Festivus. And I got a lot of problems with you, Vavilov, and I'm going to tell you about it. But I want to actually begin with what I'm happy about, which I think we all may be happy about. And there are a couple of things, and I think some of our blog posts from the West Coast touch on this. which is I am glad that we have a presumption of reasonableness coming out of the Dunsmuir decision. I think that makes a lot of sense. I think that's a good beginning point. But I'm still on the side of Mr. Justice Binney, which is all we're doing is shifting the traffic into reasonableness review rather than the selection of the standard, and that's just fine. I am very happy with the new language, the built-up language of a culture of justification and the attention to reasons, the curtailing of supplementation of poor reasoning by decision makers, I think is consistent with both the rule of law and democracy as foundational constitutional principles, as well as parliamentary supremacy. So I think all of those principles are satisfied in this newer version of a culture of justification. As Audrey and Sheila have pointed out, I welcome the return to the idea that there are people at the heart of the justice system, people like Nicholson and as David Mullen has suggested, and Baker, and others who often get left out, certainly of the appellate level decision making, as we know, as poor David Dunsmuir is hardly present in his own decision. And I like the idea that decision makers must justify their outcome, particularly in decisions where there involves an implicit or explicit proportionality analysis, where the decision really has a huge impact on a person's life. Well, so back to Paul's question. You know, you would think in a compromise that there's a certain exchange that is beneficial to both parties. And I guess my overarching question in that is, well, what did the majority actually give away to the minority? Because I see it as a bit of a one-sided exchange. Was it that they gave away true question of jurisdiction? Was it that they gave away that several of them really wanted to enhance correctness review? Because it seems to me that the minority by Madam Justices Abella and Karakatsanis gave away a lot in this decision. In some respects, to borrow a phrase from philosophy, what I see in Vavilov is that the owl of Minerva has taken flight, that at the very moment that we have begun to understand deference as respect in its fullest form, it's over. When I read that decision, there is no phrase deference as respect mentioned once. The words deference and respect appear in a number of places, but that key phrase is nowhere to be found. And I do suggest that signals a shift, certainly towards very much more robustness, reasonableness review. And for many reasons, maybe that is not a bad thing, but it is not uniformly a good thing if one still accepts deference as respect as a fundamental principle in administrative law. I think that the strength of Vavilov is its weakness, the streamlining of an approach to judicial review that oversimplifies how we determine legislative intent, where much of Vavilov doesn't square up with CUPE. I think, I know that Sheila has done this, a number of us have run exercises in our administrative law classes where we give students older cases and ask them to apply Vavilov to the older cases. And I think many of the older cases, like CUPE, like Baker, like Southam, probably Newfoundland nurses, would be decided differently on the Vavilovian approach as opposed to the earlier jurisprudence. And so one wonders about these pillars that Audrey talks about. How strong are they when the new framework maybe suggests they are a bit shaky as precedent? And I would underscore this whole problem of precedent is really quite substantial. I think, as Sheila has talked about, we still are not dealing with the complexity of the executive branch in its fullest form. That, you know, we must have an umbrella approach in administrative law, but really what's the same, what's consistent between governor and council and a minister and a municipality and a member of the competition tribunal and an Indigenous decision maker and an adjudicator? It still will, the devil will be in the details. I don't think there's any way around that. That's just the reality that administrative law is. What about the minority, which is really also what Paul asked me about? I think what I admire their spirit, but it is a spirit that's kind of stuck in the past. Many of the authorities are are authorities from the 80s, perhaps even the 70s. And the administrative state is no longer that administrative state anymore. It's a new kind of administrative state. It's a state that's now in what we now call the age of neoliberalism. And I think we have to start thinking about the reality of the administrative state, what it looks like now. And I don't think the minority did that. It's still the administrative state from an earlier phase. I think that they didn't deal with expertise as well as they might have. That looking to the United States, the fear of the administrative state as a technocracy is a strong one. And so when we talk about expertise, I think it was important not to conflate it with technocracy and the idea that that is a potential undemocratic, non-rule of law side of the administrative state. And I guess that just needs more work. And so this downgrading of expertise is also part of this kind of lack of attention to the reality of the administrative state now. Perhaps as I know some of you will disagree with me, a fourth branch of government. I think the minority didn't lay out an alternative framework. And so I'm going to disagree with Lauren. I think one of the big downsides of Vavilov is there isn't a framework. I agree that the pragmatic and functionals approach, standard of review analysis, was not exactly helpful for selecting the standard of review. But as an analytic framework, it sure is helpful in organizing the information you need to bring before a court in order to help with the contextual analysis. And so when I taught Vavilov this year and had students work through the application of Vavilov, there wasn't a lot of guidance on how to do it. One student wrote to me, I tried to start with the reasons, but I didn't get very far because I had to go somewhere else. Where do you have to go? You have to go to the statute, you have to go to the record, you have to go to the submissions made by the parties. But how do you organize that information in a way that provides for a coherent argument? The majority didn't provide that kind of analytic framework. That's why Baker has been so successful, but neither did the minority. And I think that was a real lost opportunity. Also in relation to how you can show that a decision maker may still have the interpretive upper hand if you think that in some cases they do. And so I think that they're right in their overall criticism, which is Vavilov is not going to be as simple as we hoped it to be in application. It's not going to be as predictable as we wanted to be going forward into the future, especially in relation to precedent and the very unsettling intervention of the Hausen and Nicolaisen framework. And as I think some of us all have argued in blog posts and otherwhere, it may not be conceptually as coherent as we like it to be. But what do we have instead? And I don't think we have an alternative framework that can assist with the future of Vavilov.
Well, thank you very much for that, Mary. I'm almost tempted to make a mischievous comment about the reasons that you must have provided to the students that they had to look to statutes and elsewhere to answer your question. But I'll leave that pass because you raise some important issues, and I'm going to ask Audrey something, and then I'm going to ask David Mullen something. So Audrey, we've heard from Laura now and Mary about the reasonableness framework, and as you said, most of the time you're on your feet or writing to try and convince a court to quash an administrative decision. There's a lot in Vavilov about reasonableness. I think much more in the decision than there was in the submissions of the parties and the interveners. What do you make of the reasonableness standard post Vavilov?
Well, I mean, I think the one of the questions that you had asked me kind of in preparation was, is it surprising to see that there's more meat around the reasonableness standard than perhaps there is around the selection of the standard of review in the decision? And I think it's kind of hard to compare the two in the decision because the court was just coming at it from different starting points. I think for selecting the reasonableness standard, the court was kind of in this position of having to distill down decades and decades and decades of jurisprudence and different tests and different formulations over the years. And with respect to reasonableness, it was almost the opposite problem. There had almost been no guidance provided by the court. As you also point out in the submissions of the parties, there wasn't, there were submissions and people made comments about it, and there had been proposals out there in the jurisprudence, different federal court approaches in the academic literature. But this was really the first time the court tackled this in a really meaningful and comprehensive way. And I think it's a very welcome development, but it wasn't a huge surprise after the hearing. I think it was a pleasant relief, I would say, because it became quite clear during the course of the hearing that everyone in the room, including the 9 judges at the front of it, really were struggling with what is a very we say basic in the sense of central to the concept of judicial review, which is this notion of deference and this notion of reasonableness, and what does it all mean? I mean, there were some very honest moments in the hearing. I think it was Justice Moldaver at one point who just said, how do we conduct reasonableness review? And we're all kind of thinking, well, if you don't know, we don't know. So it was, there was a really it was quite honest on the court's part that to acknowledge that there was kind of this lack of guidance going forward. So I was to see kind of the robustness placed around all the different factors that can be taken into account. And I take the point that perhaps a lot of the work has been punted to the reasonableness stage because there are so many considerations that can come to bear. But I think that is in a sense, welcome and inevitable because of the vast array of decisions that there are out there that can be potentially brought upon judicial review. So I personally, I think it was a very welcome development and something that certainly assists parties in framing their submissions around kind of a coalescence of factors that I think as the jurisprudence goes on, we'll see maybe perhaps some clearer, more streamlined analysis come out of it. But for the time being, I think it provides a good framework and a great starting point. And I was quite happy to see to reiterate the importance of reasons and that in order to defer, there has to be something to defer to. To me, that was an important reiteration of perhaps something that was there, but at times got lost, and an important step forward in terms of providing some guidance.
Thank you very much. David, as I said when introducing you, you've seen it all really in terms of Canadian administrative law, and I guess I'd ask where you think the pendulum has swung after Vavilov. Is it going to make it too easy? Are the courts going to interfere too much with the work of expert administrative decision makers, given the new rules relating to statutory appeals and the formulation of reasonableness review?
Let me start with following on from what Audrey has just said. I think one of the incredibly valuable aspects of Vavilov is the guidance that the court provides to administrative decision makers about the importance of reasons and the necessity to pay attention to the reason writing aspect of the administrative process. Where I am somewhat fearful about, and I generally see myself as a supporter of deference, where I'm somewhat fearful is in the transfer of the contextual factors that previously were relevant to the selection of the standard of review to the domain of reasonableness. And the one thing that's a little troubling, though the court constantly tries to bring us back to reality in all of this, the one thing that's a little bit troubling is that, in fact, what seems to have happened in the unexpected, to a certain extent, extensive discussion of what reasonableness involves is the presentation of a smorgasbord of contextual factors or considerations. And within that smorgasbord, it seems to me, are elements that judges who basically have no commitment to deference as a principle will seize onto. Just to take two examples. Example number one, questions of law for which, or statutory interpretation for which there is only one reasonable answer. The principles, the modern principles of statutory interpretation, text, context, and purpose, viewed from certain dimensions or from certain perspectives and philosophies, those two, along with some of the others, present an opportunity for anti-deference judges under the guise of reasonableness to descend on administrative tribunals and be much more intrusive in the way in which they conduct judicial review. So I think that's something we need to look out for. I think the court, the majority to their credit, kind of is saying, you've got to start with the reasons, and reasonableness is our commitment. There's a presumption of reasonableness, but the smorgasbord of things that you can take into account in evaluating reasonableness seems to me to be somewhat problematic. Moving from that to the more specific question about statutory appeals, this undoubtedly is something that has been seen by many commentators as the single most dramatic movement away from deference to correctness, based as it is upon the proposition that the Supreme Court makes that where there is a statutory appeal, then automatically on questions, pure questions of law, the standard of review is going to be that of correctness. Let me be quite frank. In my own thinking on this, I was never of the school that said, in all circumstances, it's going to be reasonableness on questions of law for any form of statutory appeal that came before the courts from an administrative tribunal. I think that there was, in fact, room on whatever theory you want, legislative intention, if you like, statutory interpretation. There was room in the context of certain appeals to recognize that when the legislature said an appeal on questions of law and jurisdiction, they actually meant correctness. In other words, I think the question is a nuanced one, and the context in which the statutory appeal is created is significant or important. Having said that, however, the Supreme Court, obviously, a majority in its wisdom, decided that in fact it was better to have one simplified rule, that is, correctness on pure questions of law. Where does that leave deference as far as statutory appeals are concerned? I'm not quite sure. We've got some indications that, in fact, while deference is gone as a formal concept in dealing with statutory appeals, at an informal level, there will still nonetheless, at least in front of certain judges, be a tendency on the part of those judges to actually pay attention to the reasons that have been provided by an administrative tribunal that is subject to an appeal right, and to, in fact, informally at least, pay deference to in the determination of questions of law raised in those appeals before it. And we see an example of this in Cathy Swinton's judgment in the Planet Energy case in Ontario. Let's obey the Supreme Court. Let's pay attention to the reasons that have been given. When those reasons are developed carefully by a tribunal that is subject to a statutory appeal, there may be an informal form of deference. Now, beyond that, of course, what we know is that in the statutory appeal context, once one moves away from a pure question of law to mixed questions of fact and law, from which there is no readily extricable question of law, to questions of fact, deference reigns in those domains anyway on statutory appeal, albeit under another moniker, that moniker being palpable and overriding error. And as Paul has written about questions, and many people have written about, there are questions arising about whether or not palpable and overriding error is just a form of unreasonableness in that particular context, and therefore there's not been much change, or is it a more intrusive or less? That remains to be seen how that's going to be worked out. But there is, fairly obviously, room for deference to be paid in the context of statutory appeals. And of course, one of the contexts in which these things often happen is in the context of major regulatory agencies where there is an appeal to the court on leave, on questions of law and jurisdiction, and then there is a privative clause protection for anything else. And that, of course, means that at least in that domain, there's the possibility that unless you can extract a pure question of law, you ain't going to get leave, you ain't going to get before the court in any event. So that's about the best that I can do on that at the moment. But I think this is an area that needs to be watched.
Well, thank you very much for that, David. We're coming to the end of this session, but there's been a question, and I was going to maybe throw it to Sheila, but I'm gonna throw it with some spin. So the question is, how about legislatures reacting to Vavilov, and are they now resorting to codified standards of review or statutory appeals? Or are they not bothering with privative clauses? It's probably a bit early to say on that. But I guess one of the interesting things, perhaps, Sheila, you talked about the participatory get-together that was Vavilov. And the court heard from all sorts of different people, but didn't hear from any legislatures, didn't hear from any legislative drafters. And in many ways, standard of review is a legislative problem. Do you think there was, perhaps it's impossible to incorporate their views into this, but do you think that was a voice which ought to have been heard in the Vavilov get-together?
It's very interesting question. I'm sure that it would have added value. Of course, courts tend to regard themselves as, the expert channels of interpretation of legislative intent, and so that's what we saw happening in Vavilov, I guess, with bells on, in the sense of, imputing to statutory appeals quite a strong reading. Now, whether that might have been tempered by listening to legislatures around, what was actually informing their thinking as they inserted those clauses in very different contexts and sometimes using very different language, is something that is definitely worth speculating on. But now I guess the question really is the one that was posed, which is, what will the response be from the legislative side? The only thing I would add to that, and I think it is worth our putting on the table as we start off, these day-long conversations on Vavilov, goes to more a question around the executive and what kinds of resources will be invested in administrative bodies to do the work that's been asked of them under reasonableness review, which we've heard, from various folks, it is a set of robust requirements, and it comes at a time, the Vavilov ruling comes at a time, at least in this last year, we've seen administrative tribunals, some would say, under attack, particularly those with social welfarist ends. So, Tribunal Watch Ontario, for instance, has brought together some recent incursions on resources and independence of various administrative justice bodies, Social Benefits Tribunal, Landlord Tenant Board, Human Rights Tribunal, understaffing and resourcing and delay are, I think, among the things that we should be watching as folks concerned with administrative justice, just as closely as we're watching what the courts do and what the legislatures do.
Well, thank you very much for that. We're going to have to wrap up this session. I see in the Q&A that my colleague John Mark Keyes notes in relation to that question about legislatures that governments appeared in Vavilov, and asks rhetorically, I think, John Mark, did they present a legislative perspective? And I suppose that's the point there, is that this tension between the executive and the legislature, and the AG should perhaps speak to both, but might not inevitably do so. Nigel Banks points to Bill 48 in Alberta, which does codify a standard of review of reasonableness. I can't remember which tribunal, but I have seen the example, and it's definitely apropos. Thank you, Nigel. And should also say in Bill C-20, the federal privacy bill, there is a clause on the standard of review to be applied by the new Information and Privacy Tribunal, which makes reference to palpable and overriding errors. The first time any statute has made that reference. All right, and then I have my former colleague and friend Stefan Bolak talking about asking a question about the domestic use of international law and looking at the referencing the rule of law and legal predictability, and was wondering about whether procedural review was addressed in Vavilov, and whether it's going to have to be addressed at some point in the future, and wondering whether Vavilov is a limited series, or whether it's going to be there's going to be subsequent seasons. So we've had season 1 of Vavilov on substantive review, and maybe we'll have season 2 on procedural review. That's Stefan's question. Why don't we all have a think about that over the next 15 minutes or so, and we'll come back in 15 minutes with our second panel, where we're going to dive into various areas of administrative law, economic regulation, labor law, immigration law, and environmental law, with Christy Ford, Steve Barrett, Jamie Liu, and Stephanie Hua. So for this, to close the first panel, thank you very much to David, Lauren, Audrey, Sheila, and Mary. It was great to hear from you all, and thank you for your perspectives.
Thanks very much for having us.
You
Well, hello again, everyone, and we're about all set for panel two. Panel two is going to feature Christy Ford, Steve Barrett, Stephanie Roy, Jamie Liu. And as I said, in panel two, we're going to discuss various areas of administrative decision making and the impact that Vavilov has had or is likely to have. So we discussed in the first panel how Vavilov covers a vast array of decision makers in everything from general economic regulation to life and death matters in prisons and immigration. It sets out these general principles of reasonableness, which have to be applied in specific areas of substantive regulation. And there's an age-old tension in administrative law, or at least in contemporary administrative law. There's a tension that goes back many decades between courts setting out general principles of administrative law, such as reasonableness and procedural fairness and so on, and then them being applied in particular areas. So courts articulate general principles, but then have to apply them to specific areas. And sometimes there's a mismatch between the general principles articulated and their application in specific contexts. And one of the challenges for people studying administrative law and practicing administrative law is taking those general principles and applying them to specific areas of substantive regulation. And so that leads to some questions about the implications of Vavilov and whether they're going to be the same across the board, whether Vavilovian reasonableness review is going to be robust or restrained in different areas and to what extent. And over the medium to longer term, is Vavilov going to have to be recalibrated in some way or any way in order to account for differences between different areas of regulation or decision making? Or well, recalibrated is one way to put the point. There may also be a fear that Vavilov might be manipulated to achieve results which judges feel are just in the particular context of a case. And so I'm really interested to find out from these experts in different substantive areas of law what the implications of Vavilov are going to be. I'm going to start with Professor Christy Ford. Christy is a professor of law at the Allard School of Law at UBC. And thank you for getting up early to be with us, Christy. And you're an expert in securities regulation. And I thought I'd start by asking you whether the concurring judges' assertion that deference is dead or dying reflects the reality of how Vavilov is going to be applied and influence securities regulation, which is your area of expertise.
Well, thank you, Paul. I'm coming to everyone from the traditional, ancestral, and unceded territories of the Musqueam, the Squamish, and the Tsleil-Waututh people here in Vancouver. And it's a pleasure to be part of this very fun event with such a great group of administrative law colleagues. So I guess the short answer to your question, Paul, would be that yes, I do think that there is a real possibility that what we're going to see, at least around the economic tribunals, is less deference than we've seen so far. So it's worth remembering that it was the economic tribunals that got us started down the road to emphasizing expertise in the first place. And so it was PESM in 1994 and SEDM in 1997, which established the idea of reasonableness simpliciter, specifically in an area where a tribunal had a statutory right of appeal and no privative clause, and yet was recognized as having a lot of expertise. That's why we had reasonableness simpliciter in the first place. And with the Vavilovian pushback against PESM and SEDM, that's what is being pushed back against. And so I think distinguishing characteristics in this area would be, first of all, that a lot of administrative tribunals around economic regulation do have statutory rights of appeal. And so the new Hausen and Nicolaisen or the renewed Hausen and Nicolaisen standard will apply to a lot of economic tribunals. The second point that I think is relevant here is that most of the time when we're looking at economic regulation, the party that is challenging government action or regulatory action is likely to be a well-funded corporate litigant with access to creative and well-remunerated counsel. And so what we will see, I think, is pushback by a very particular kind of litigant against government action. And so I think the impact of Vavilov in this area will be that judicial review will become more common and or statutory appeals will become more common, and both are options. Corporate actors will succeed more often in pushing back against regulatory decisions. And I think the knock-on effect then will be that regulators themselves may become chastened when they think about the massive costs of defending any decision against these parties in borderline cases or cases where they're required to exercise a level of discretion. So in the last panel, Mary Liston talked about the idea that we are in an era of neoliberalism. And I guess I want to expand on that a little bit. So in one of the earlier versions of our administrative law in Canada, or in context textbook, Audrey Macklin suggested, and I think she was right, that in the era after Densmere, but before Vavilov, it was really remarkable the degree to which economic tribunals were experiencing deference from courts relative to other areas. So courts would not defer to human rights tribunals or many other immigration tribunals and the like, but they would defer to economic tribunals. And what she suggested, in fact, was that the entire standard of review project was a bit of a shell game, and that you could predict whether a tribunal was going to be deferred to or not more based on what their subject matter was than based on what the official standard of review would have been. And I think this is an important consideration when we think about how economic tribunals are understood. I mean, economic expertise is not more esoteric, it's not more marvelous, it's not more complex than expertise in other areas. And I think what we saw was this privileging of economic expertise and the sort of deference to these financial masters of the universe in the years, well, both before Dunsmuir in 2008 and also after. Now, I do think that economic expertise on the part of tribunals like the Competition Tribunal is in fact very important. It's just that they're not all that special that way. So we had a background of a sort of a neoliberal preference for economic forms of expertise, which we were seeing in cases like Pesum and Southam. Now, after Vavilov, that's gone, but I don't think it's because Vavilov is engaging in some post-neoliberal critique of the economic order. I think, on the contrary, the decision is very much pitched at a different register, and it's about the battle for authority between courts and tribunals. And so Vavilov now asserts that the statutory right of appeal, the presence of a statutory right of appeal, is really determinative evidence of a legislative intent not to defer to that tribunal's expertise. And so where there's a statutory appeal right, you treat the appeal and the standard of review on judicial review will also be like an appeal from a lower court on the Hausen and Nicolaisen standard. And I hear the minority opinions critique that this is really a profoundly traditional, they use the word textualist approach to interpretation and to really the absence of deference. So if I can just make a couple sort of high points about the world of economic tribunals. The first one is that a striking number of what we might think of as economic tribunals or regulators do have a statutory appeal right in their enabling statutes. So the Competition Tribunal, the Office of the Superintendent of Financial Institutions, which is our banking regulator, securities commissions across provinces, and the Autorité des marchés financiers in Quebec as well, the CRTC, the new Canada Energy Regulator and its commission, all of these important economic tribunals have statutory rights of appeal. Why are there so many statutory rights of appeal in these provisions? I would have to check Hansard, and I look forward to doing so. But I think we could see that as actually a business-friendly effort from the middle years of the last century. So as these economic regulators were emerging, it's almost as though there was a carve out in this sphere for private commercial action, within which the regulatory state was constrained. And so looking back to legislative intent from that period, maybe what we really are seeing is a scope for private activity, private commercial activity, where regulation was intended to be less, I guess, autonomous from the courts, and so that's what we are potentially going back to when we refer to legislative intent. In terms of the Howson and Nicolason standard, what this means is that for economic tribunals now, as Paul has suggested, on pure questions of law, the standard of review is correctness. On questions of mixed fact and law, it is palpable and overriding error, as it is for questions of fact. There's lots of grist for the argumentative mill in Howson. This was a tort case. It was from 2002. It was a 5-4 split decision. It was before Dunsmuir, when back in administrative law, we still had 3 standards of review. It cites Southam on standard of review, which of course we now know one ought not to do. I think there's going to be lots of room for figuring out what Howson means in the context of economic regulation and judicial review. But if we apply it sort of facially, I think it's quite clear that almost all of the major economic tribunal decisions of the last 15 years would have been decided differently. Pesum would be on a standard of correctness. Southam, asbestos minority shareholders, which is a big case about the public interest jurisdiction of securities commissions. McLean, 2013 Supreme Court of Canada case on securities. Bell and Canada, the companion case to Vavilov, which would have been assessed on a reasonableness standard previously, is now assessed on a correctness standard. And I would just point out that the business law bar is in fact very happy about this development. And so what we see in, for example, the blogs of the business law firms evaluating Vavilov, as well as a case called Tervita, which sort of anticipated Vavilov in the economic context, and in other cases since, is a recognition that following Vavilov, it is harder for regulators to actually enforce certain parts of their mandate aggressively, and it is easier for business actors to obtain successful judicial review because the standard of review is more likely to be correctness.
Thank you very much, Christy. I just want to, Professor Banks posed a question slash comment in the Q&A, which you might want to speak to. So he references the 2006 decision of the Supreme Court in ATCO, and suggests that it had this was another split decision, if memory serves me, about the allocation of resources from a sale of a utility company's property. I think I have that right. I'm ad-libbing, so I'd like a margin of appreciation if possible. And Professor Banks says that this really did have a chastening effect, at least on Alberta tribunals, and may provide a vision of the future in terms of the effects of correctness standard of review for points of law. So that chimes with what you're saying, I think. The ability of corporations to go to the courts and try and get points of law determined in their favor. Does that sound right?
Well, it does sound right. My memory of ATCO is a little shaky, but that it conforms with your memory of it, Paul. Another precursor that I think is interesting is the Tervita case, which I mentioned. So this is 2015 Supreme Court of Canada. It's a case regarding Tervita Corporation and the Commissioner of Competition. And I think it's very interesting because in this case, the court said that the presumptive standard of review for a question of law for the competition commissioner reviewing its own enabling statute would be reasonableness, but that the standard of review, that presumption was rebutted in this case. So they went with the correctness standard of review on this question of law, and then proceeded to wade in quite a lot of detail into exactly how the competition commissioner evaluated the potential anti-competitive effect of a proposed merger in a way that to me looks an awful lot like a question of mixed fact and law. But the result was that they imposed a very significant evidentiary burden on the Commissioner of Competition to sort of buttress their decisions in a way that we hadn't seen previously. And it's that same kind of chastening effect that we see also in ATCO, and that I feel as though I have seen more than once in the Securities Commission context, especially when dealing with well-founded and creative, or well-funded and creative counsel on the other side.
Oh, thanks very much for that. Next up, Steve Barrett. Steve is the managing partner at Goldblatt Partners in Toronto, one of the country's leading labor law firms. So I mentioned on panel one, Steve, and of course you represented an intervener in Vavilov as well. As mentioned on the first panel, the origin story of Canadian administrative law involves labor tribunals are really central to the push for deference, and then the articulation of doctrine of deference in the 1970s and 1980s. Labor tribunals really were central, but now there may be questions about whether it's going to be as easy for labor relations decision makers to have their decisions upheld post Vavilov. Where do you think we're headed in terms of judicial review in the labor relations area?
Well, I do think that you wouldn't know from reading Vavilov about that history. And you've just written an article. You seem to write an article a week, but you just wrote an article on Canadian labor law after Vavilov, and you trace that history. And so I'm not going to do that here. But there is a somewhat ahistorical revisionist approach taken by the majority in Vavilov to that history, which I think has implications for the question you asked, because that history is one where the twin factors of expertise, experience, accumulated experience, specialization, but let's call it expertise, and privative clauses, strong privative clauses, actually resulting from a tension between interventionist courts and legislatures that were trying to back courts away from intervention in labor law in particular. That's what gave rise to deferential review in administrative law. And I think the real question is, given the Vavilov majority's complete de-emphasis of expertise in terms of explaining the standard of review, and it's ignoring altogether privative clauses in explaining the standard of review, a deferential standard of review, especially for labor tribunals, what impact is that going to have on future reviewing courts in the area of labor law? And we've seen a move from New Brunswick Liquor patently unreasonable, and I am still perhaps alone out there a proponent of patently unreasonable, because I think it meant something in labor law. And the Supreme Court of Canada, actually, I think it's in West Fraser Mills, where they're expounding on the patently unreasonable statutory standard in BC, says that means that the court should accord the utmost deference to a tribunal's interpretation of legislation. And so we've seen this evolution away from patent unreasonableness the development of the mid-tiered reasonableness standard, as Professor Ford has explained in the context of appeals. And then Dunsmuir eliminates patently unreasonable and subsumes everything to reasonableness. And now we have Vavilov basically potentially developing reasonableness with more bite. And so to the extent that there's a shared consensus, and I think there is unusually, there's not much that union and management lawyers agree about in the world that I operate in, but there's generally been a shared consensus that we ought to keep the courts out of labor relations, and we ought to have relatively expeditious expert labor tribunal decisions, for the most part, govern absent a serious error. And the question is, as I say, now that expertise and privative clauses are no longer particularly relevant, what does that mean for labor law? And the reality is that, and I'm most familiar with the decisions in Ontario, and for the most part, Ontario courts engaging in labor law judicial reviews of labor tribunals, have continued to defer in the usual manner. There's one exception that if I have time, I'm going to get to, but I think it's an unusual case. And there's certainly enough in Vavilov to keep deference alive for those judges inclined to be deferential. But Vavilov also contains enough to encourage other judges who might tend to be more interventionist to be so. And if those judges are getting their only history of the development of judicial review from Vavilov, which ignores the role, the importance of deference in labor relations, I'm certainly concerned that we might see more interventionist, more intrusive review. And to that end, I just want to highlight a few areas of concern from what I think Professor Mullen referred to earlier this morning as the smorgasbord of factors that may limit or negative deference. And some of these have particular resonance when it comes to labor law. The first is, Vavilov emphasizes in explaining how reasonableness review is to be conducted, that there are legal and factual constraints that bear on decision makers. And the problem for deference review, including in labor law, I think is twofold. First, the very language of constraints seems somewhat foreign to deferential review. And second, it's not clear what role deference plays in the reviewing court's identification of those constraints. And so these two factors create the risk that in purporting to carry out reasonableness review, a reviewing court won't be constrained by deference because it's for the reviewing court to identify the constraining factors. Secondly, there are signals of concern, and this has a particular resonance in labor law when it comes to questions of legal interpretation. I think it's paragraph 108 of Vavilov, where the court says that, of course, the decision must comport with any specific constraints imposed by a legislative regime, including statutory definitions, as if the court is going to be the master on statutory definitions. But the whole history of judicial review in labor law, dating back, I think, to the 1971 Metropolitan Life, where the question was, what does it mean to be a member of a union? And the Supreme Court of Canada disagreed with the Labor Board's interpretation of what it meant to be a union, substituted its own view. And that case was roundly criticized by labor academics and lawyers. But if it's for the courts to, if statutory definitions are a constraint, another signal that deference in labor law may be at risk. Third, when the court talks extensively about the Rizzo case, I think it's in paragraphs 117 to 124, at one point, they say reviewing courts are to determine whether, and I'm quoting now, whether the merits of an administrative decision maker's interpretation of a statutory provision must be consistent with the text, context, and purpose of the provision. And in my view, the distinction between whether a tribunal has followed the Rizzo approach or misapplied it is a tenuous one, and again risks greater intervention in the labor area, whether in interpretation of legislation or collective agreements. Another area is findings of fact. There's been a traditional sense in the labor area, especially in labor, that where you have a privative clause and limited review, the test is no evidence. That's the Ontario Court of Appeal decision in Keepright, followed, I think, a year or two ago in Ontario in a case called Prescott Masonry. How does this now play out in labor law? Is the test now whether the factual finding is unreasonable? Is it reviewable on that ground if even where there's some evidence, but the reviewing court doesn't think the arbitration board or the labor board reasonably assess that evidence? And of course, generally speaking in labor law, we don't have transcripts of evidence. And so are we going to now see, as there's at least one case where there's affidavits about, what the evidence was in the hearing that a court is somehow going to wade into. And then finally, in terms of some of the concerns that I have, is the court's reference to the importance of the interest being a factor in the intensity of the review. Now, I understand how that may be relevant in other contexts, but it's unclear how it plays out in labor law. There's often important interest at stake in labor law, harsh employment consequences, loss of livelihood. Is there now going to be more intensive review where an expert labor tribunal is interpreting a statutory or collective agreement provision depending upon the nature of the interest at play in any particular case? Now, having said all this, it may well be that courts will find that in the labor law context, privative clauses and expertise are still relevant, that they form an important part of the overall context, and therefore that these factors point to, a relative absence of constraints on labor tribunals and therefore a relatively higher degree of deference. And to date, as I said at the outset, is a practical matter, and I think this is true generally across the country. This seems to have been the approach taken. Now, there is one case, time permitting. Do I have time, Professor Daly?
Of course you have time. You know what? Are you going to talk about Scarborough Health Network?
Yes.
Okay. You know what? I'm gonna tee this one up for you.
Okay.
Because I have there's something you said which provides a nice link to the Scarborough case where we have different views, as people are going to find out. Just before we get there, there was a question in the Q&A from an N. Dodd asking whether it's easier to challenge administrative tribunals' finding of fact on judicial review than on a statutory appeal. I think the answer to that is yes. That's what I think. And that fits in a little bit to what Steve was saying. The divisional court, in a couple of cases, which I'm just going to send the references for now in the chat, has said we shouldn't be conflating reasonableness review and review for palpable and overriding error. So they say, don't be making these comparisons at all. This is dangerous territory. Stay out of it. But I think it's inevitable that people will make those comparisons, and I think it's certainly easier on judicial review than on palpable and overriding error. Because at the end of the day, a palpable and overriding error has to be palpable in the sense it needs to nearly leap off the page,
Almost like
and it has to be overriding. It has to go right to the root of the thing. Anyway, Steve, you said, and I quote, that there is a consensus in the labor relations community that it's better to keep the courts out. Leave the parties, who are all consenting adults, come to their own arrangements about the way forward. But isn't there a fundamental tension between that consensus and the idea underpinning Vavilov, which is that exercises of public power must be justified in reasoned decisions, justified to the public and to the people who are affected by the decision? And that, I would say, is the central tension underlying the decision in Scarborough Health Network.
Yeah, well, I guess it depends which community you're justifying your decision to. And one of the issues you raise in that article you wrote is, the labor community is in some senses an insular community. We speak in code. There's certain expectations and cultural norms, and here we have a general judicial review, Vavilov, general principles, general requirements, and there's no doubt attention. And I think the Scarborough case illustrates that. And just very quickly, the Scarborough case, Cupian and Scarborough was an interest arbitration. That means that the arbitrator was not interpreting a collective agreement, but actually determining the terms of the agreement, the wage increases, other monetary terms, non-monetary provisions of the agreement. And there'd been a merger of two hospitals. And the general norm in such a situation is that the wages are harmonized upward. Same workers doing the same job at two different institutions, they're merged, the wages are harmonized upward. That's both what arbitrators have held and what parties generally agree to. Scarborough Hospital said, well, no, yeah, we accept that's the general norm, but we say we're different. And they gave a bunch of reasons that they were different. And the arbitration board, in its reasons, simply said, we're following the general norm. And pre-Vavilov, I'm pretty confident that that decision would have been sustained. And in fact, I went back and looked at the factums pre-Vavilov because the case was argued orally after Vavilov, but written factums were filed before Vavilov. And in its written factum, the employer said, oh, the arbitrator's decision is unreasonable, didn't consider appropriate factors. And by the time we argued it orally, the employer had very intelligently, good lawyering, said, no, the problem with this decision is it wasn't responsive to the main argument we made, which was our situation is different. And the arbitration board simply said, we're following the usual pattern, but it didn't explain why it was rejecting the argument that this employer was in a different situation. And so respectfully, I think the divisional court got it wrong because I think it wasn't sufficiently sensitive to the unique context of interest arbitrations, where often there's lots of reasons not to give reasons. So, because sometimes the reason is I awarded X to the union and therefore I'm not going to give the union Y. But is that a reason? That's the real reason. Sometimes it's that I gave the employer this, so I'm going to give the union that. Sometimes the reason is that the nominees, because there's often nominees in interest arbitration of the two parties, have been sent off and they've agreed to most of the outcome. The arbitrator has no idea what the reasons are, but it's better that the parties agree because the nominees are proxy negotiators. What reasons is the arbitrator to give in those situations? So I think had sufficient attention been given to context, perhaps the result would have been different. One postscript, one postscript, which is we decided not to appeal to the Court of Appeal. Instead, it went back to the arbitration board. And earlier this week, the arbitration board gave far more extensive reasons than I believe any interest arbitration board will ever give, because even the divisional court acknowledged reasons can be quite brief. And the arbitration board, after hearing further submissions from the parties, gave extensive reasons as to why upward wage harmonization should occur. And the dissenting employer nominee said, I accept that this time the arbitration board has at least responded to the arguments made. I would have come to a different conclusion. So I don't think we're going to see further review of that case. And it does raise the question, I suppose, as to in the particular context of that case, was it maybe Professor Daly, you would say, well, now at least the employer knows why it didn't succeed because there's 50 paragraphs or pages of reasons. But I think the employer knew why it didn't succeed even before it brought the judicial review.
I would react to that, but I'm so traumatized that you didn't seek to appeal the decision that I'm going to have to move on to something else. Thanks for that and for those reflections. Now, from economic regulation, securities, through labor relations, on we move to immigration. And my colleague, Professor Jamie Liu, is with us. Jamie, in the Canadian Bar Review, you have an excellent article entitled "The Good, the Bad, and the Ugly" of Vavilov, and you talk about the good, bad, and ugly aspects of the decision from the perspective of vulnerable people and marginalized communities. A year on, do you still think that it's good, bad, and ugly, or has your perspective shifted somewhat?
So thank you, Paul, for organizing this event and for the invitation to talk. And I just wanted to acknowledge that I am speaking from traditional territory of the Algonquin Anishinaabe people. And I also wanted to acknowledge what Sheila had said earlier, that, you know, I recognize that administrative law takes place in a number of contexts, and much of what I'm going to say is probably going to be very different than what, for example, Stephen has expressed in his legal context. So it is interesting to always see how law can be experienced quite differently in different contexts. And I also was inspired by David's fictional discussion between lawyer and client, and thought I would give my own rendition of what this conversation would look like from the perspective of an immigration lawyer, where the lawyer would approach their client and say, guess what, the government's appealing your decision. I'm sorry that we have to respond to this, but it means that your decision's in flux. Client saying, well, what does that mean? What are they appealing? How can they appeal this? Doesn't it say in the law that, you know, spies are not included in this legal provision? The lawyer says, well, the government disagrees. They're arguing that it's, you know, reasonable to interpret this decision to include, you know, children born of spies. And the client says, but it doesn't say that. And I'm really confused. The lawyer's saying, well, you know, the courts are going to, you know, try to figure out what is the best approach, whether, you know, it's under the standard or whether it's a reasonable interpretation. Client saying, well, isn't it just whether it's a right decision, right interpretation or not? What does this mean? Isn't that what the court did already? They said this. So I think it's interesting from the immigration law perspective for many of us that we take for granted that some of our clients don't understand that the courts are not willing to take up what they see as part of their wheelhouse, which is to interpret the law. And I think, you know, for those of us working in the immigration and refugee law context, you know, we don't have the same confidence, or we don't see some of the decision makers in the administrative law context as having expertise, I would say. And this is, you know, something that I'd written in the paper about what is a possible ugly outcome coming from Vavilov. I know there's a lot of disagreement about whether or not expertise should keep or should have stayed within the realm of how to decide whether or not a standard of review should be taken up in a particular circumstance, and now has been moved to the reasonable. So I don't, you know, think it has gone away. And for those of us that are concerned that this factor doesn't play an important role, it still does play an important role in the way in which the reasonableness standard is applied. And I think that is, you know, for me, a bit of a concern in the immigration and refugee law context. We often are confronted with a variety of administrative law decision makers. And many of you might think that the Immigration Refugee Board represents the administrative decision maker in a lot of cases. But we sometimes are confronted with decision makers at borders, officials at inland citizenship and immigration offices that make frontline decisions or screening decisions that often have very profound legal consequences, such as the decision of whether or not someone is eligible to make a refugee claim. That is a humongous decision that provides a barrier by which someone can further make a claim and go to the Immigration and Refugee Board, where there might be more quasi-expert decision-making happening there. But all this to say is that I think, you know, the court was right to take out this idea of expertise from the standard of review selection, because ultimately my view is that what is expertise? The court has never really spent a lot of time discussing how we evaluate what is expertise. What do we do about situations where there's differing degrees of expertise within an administrative body, within an area of administration or regime in which there are clear differences in degrees of perhaps legal expertise, subject matter expertise. I mean, we really don't know what we're measuring and what we can turn to in terms of how we attribute expertise to a particular decision maker. And so I think this is something that we have always been complaining about, especially when it comes to selection. And so it is definitely become easier for us to say that is not an important consideration at this point. Now, when we're talking about the reasonableness and applying the reasonableness standard, expertise does come back into play, and it informs whether a decision was reasonable. But I think I want to, I guess, go back to the heart of what Vavilov was about, which was, it was a case about statutory interpretation. And I think that, you know, while the court was inviting everyone to think about the approaches to administrative law writ large, that we can't ignore that the decision at the heart of Vavilov dealt with a core issue of interpreting the law. And I think for those of us working in this field, you know, I think one of the more ugly aspects of this decision, if I may, is that there is, I would say, a less principled approach to dealing with statutory interpretation, to say that, you know, we will allow a system to create divergent approaches to interpreting the law, creating different outcomes for people who may be similarly situated, and facing different outcomes simply because of the decision maker they are in front of. And the court really, in my mind, provides a very unsatisfactory answer to people by saying, well, this is what the administrative system, this is what we have to put up with for enjoying an efficient administrative system, for having this kind of system. And my response to that is that, well, you know, you've spent a lot of time in this decision to recognize the importance of the decision to individual interests. You spent a lot of time recognizing that some of the constraints or barriers upon decision makers relate to, for example, international law or legislative constraints, and especially in the immigration and refugee law field, where our legal constraints come from our international legal obligations to adhere to the Refugee Convention and the Convention Against Torture, for example, that we can't really afford to have divergent, like wildly divergent views of statutory interpretation in this realm, especially when it can lead to fundamentally different results for similarly situated persons. And I would just say that the court is not, you know, once we move immigration refugee law cases through the courts, it's really, the problem rests with the lower courts, not so much with the Supreme Court of Canada. You see cases like Ezekola and Tran, where the Supreme Court of Canada had no problem applying a disguised correctness standard and providing one true interpretation of a statutory provision. But then when we're, you know, at a judicial review at the federal court and perhaps at the Federal Court of Appeal, we see this kind of deferential approach saying, well, it's okay to have some, you know, decision makers interpret this word in, you know, this refugee definition as one way, and this one, you know, in another way. In this case, it was done reasonably, you know, and I think that is very problematic, and it gives a very unsatisfactory answer to whether or not the courts are there to protect the rule of law and to protect consistency and the same kinds of outcomes that could arise from legislative choice. I guess, you know, the good side of the story for me, as I explained in my paper, is that there is now a more robust reasonableness review, but I did also mention that it is really kind of just recognizing what's been already happening. I did a quick review of statutory interpretation judicial reviews over the last year in the immigration and refugee law context. And there weren't a lot of cases specifically with immigration and refugee law statutory interpretation, but the ones that I did see, I would say that, you know, the courts are not really acting any differently than what they did before. And outside of the statutory interpretation realm, I would say that, you know, it's business as usual, with a little bit more heft maybe sometimes, but I think the courts really have left the door open to allow themselves to take up certain things from the Vavilov decision or not. And I think it still allows the manipulation of how to fit an outcome with the reasons that were given. And so I guess, it comes back to my original response when it comes to statutory interpretation. Even though there is this sense that you can apply reasonableness, I think it really is a disguised correctness standard. And it will be interesting, I think, because there are a number of cases that we're watching through the immigration and refugee context that will be moving through the courts. And it will be interesting to see how the courts, whether they maintain the approaches they've taken in past decisions, or whether there is going to be a more, different approach using the language from Vavilov. So I guess I just want to close by saying my 1 year later, my views have not changed, and the cases that I've seen coming from, the judicial reviews at the federal court, especially, have not really given rise to anything different than what we were seeing before. Perhaps there's more attention paid to the individual interests. I would say that the reasons provided have not also really changed in contexts where you expect reasons to be provided in more robust manners. They might be doing that a little bit more now. I did see conversations with particular tribunals in informing members of the need to provide better or more robust reasoning. But then you see frontline decisions such as screening decisions about eligibility to make a refugee claim. These things are also still done in a very perfunctory manner. So it hasn't, in my mind, changed all too much. And to say that I think that the views that I wrote a year ago following Vavilov still are maintained today. So thank you.
Can I just ask, Jamie, based on what there's I'm sure the attendees will appreciate the very striking contrast between what Steve would like from judicial review and what you would like from judicial review, and even perhaps between what you've just said about statutory interpretation and what Christy was saying about statutory interpretation. Is it ever going to be possible to devise a set of general principles of administrative law that will satisfy you and Steve and Christy?
I think that's a good question. And I did take note that I thought Audrey Proctor earlier this morning did mention that it's so difficult to kind of map out the context under which administrative decisions are being made. And I don't know. I mean, we all sit on various sides of the spectrum. And I think it would be very hard to do that. And I do think that each context will interpret Vavilov in a way that fits with their context. And I do have to say, though, that, it's interesting that Steve did say that, in that kind of bubble or context, things might just continue to happen the way they did before, especially because the parties seem to agree on those kinds of approaches. In the immigration refugee law context, the parties are a little bit more adversarial, I would say, and they don't quite agree. And there is a huge power imbalance between the parties. And so I think if you are going to provide context-specific answers to things, that they have to be alive to what the power imbalances between the parties and the specific context. But at the moment, I think it would be very difficult to find an approach that would satisfy a lot of people because of the very different approaches to how people are responding to decision makers and how they view decision makers.
All right. Well, that's a good point to bring Stéphanie Roy into the conversation from Université Laval and the Pierre Trudeau Foundation, Fondation Trudeau. Stéphanie, I guess, if I were to really oversimplify things, I might say that environmental law is at the intersection of the tension that comes out from Steve and Jamie's different perspectives, which is that on the one hand, environmental law is concerned with economic regulation. It's the regulation of economic activities and what's permissible and what's not permissible. But then on the other hand, it has a significant impact on individuals, including Indigenous peoples. in the Canadian context. And then my question to you is, as someone who's an expert and an advocate in this area, what do you think Vavilov portends for environmental regulation? Are we going to see a more robust regime of judicial oversight, or is judicial review likely to be restrained of environmental decision making?
Thank you, Paul. Thank you for inviting me. I'm glad I can participate today in this panel here from Montreal and the unceded and traditional territory of the Mohawk. That is a good question, and probably a lot of what I'm going to say will resonate with what other speakers have said. But I would start by saying that behind your question is underlying a more fundamental question, that is, what is more beneficial to the environment? Is it leaving more space for specialized decision makers to make decisions based on science and their expertise? Or is it more court intervention to make sure that the rule of law is respected and that the purpose of environmental statutes is respected by environmental decision makers? And I think we have to find a balance between both. Because I know for a fact that as I'm involved in an environmental NGO doing environmental litigation, I know for a fact that sometimes environmental decision makers interpret the public interest as being synonym with economic interest, probably a result of the neoliberal approach to the idea of public interest. And so we need court to make sure that the way discretion is exercised in environment is respectful of the purpose of environmental statute. And then I thought in more practical terms, if I want to answer your question, will it be more restrained or more extensive? And there are two things I thought about. One is related to statutory appeals, and the other is related to the question of authority. As Professor Ford has said earlier, the fact that statutory appeals now, that the appellate standard applied when there's a statutory appeal, it very much touches on environmental issues, because there's a lot of environmental regulators that have statutory appeals. That's the case in Quebec for the Administrative Tribunal of Quebec for decision concerning agriculture. It's the case for the Alberta Energy Regulator and the Alberta Subdivision and Development Appeal Board. And it's also the case of the Canada Energy Regulators Commission decisions. So it's not negligible. And it means that all decisions that concern statutory interpretation, that touches their area of expertise, are now reviewed under a correctness standard, and whereas they used to be reviewed on a reasonableness standard in the past. And so I was a bit concerned that it means more court intervention and less predictability for citizens as to how the regulators will interpret the law. But at the same time, I realized that court would probably use the qualification of the question to maybe apply deference on question that touches or that are a mix of facts and law, which is often the case in environment. And so I'm not sure what will be the impact of the statutory appeal case. I've checked in the case law, and I've seen that courts have applied, and I've given you example with, and the reference will be, I think, posted in the comment section, but in the Borgel versus Paint Earth case and East Hants case as well, they both involved statutory interpretation related to the Home Statute of the environmental regulators, but the decision was in the first case I think they were both quashed, but on different reasons, one for procedural fairness, one for a question of authority. And therefore it's hard to say how it will impact, because those examples, even though they apply correctness, the result is the same that it would have been earlier. And the other thing, so yeah, I'm a bit concerned about this case of appeal standard, but I don't know how it's going to turn out. And the other thing I thought about was the question of authority, because in Vavilov, the court has said that question of authority are not reviewed under correctness standard anymore because they're hard to qualify, and therefore they are subject to the reasonableness standard for the future. But in environment, there's a lot of cases that involve questions of authority. Could the minister or the administrative body deliver the permit, modify the permit, revoke the permit, or oppose a certain act? And so now I'm a little bit concerned of what is going to happen as reasonableness apply, but I've realized, again, looking at the case law, that courts apply different level of deference when they apply reasonableness to these kind of questions. So there are cases where they apply a more differential approach. One example is Sierra Club of BC Foundation, where it would have been in the past a question of authority that was involved. And the court, nevertheless, was very differential in the way it reviewed the decision. There wasn't any reasons given, and yet the court looked at the record and found that the interpretation of the statute was reasonable. But in other cases, it was a lot more scrutinizing. So two examples of that would be in Nation Rise Wind Farm and Alexis versus Alberta, where the court went into a lengthy statutory interpretation that resembled correctness a lot. And so I feel that it's very hard to predict, again, how it's gonna turn out, the way that these questions of authority are now subject to reasonableness. And therefore, the fact that more questions related to interpretation of their home statutes are now subject to correctness when there's an appeal clause, but that questions of authority are subject to reasonableness, I don't know, maybe it's gonna balance out, but it's kind of hard to predict, even looking at the case law so far. Yeah, so that would be my first answer to your question. And there are other implications for the duty to consult that are also concerning an environment, but I don't know what questions you want to address for the remaining of this discussion.
No, I think we can carry on and talk about the duty to consult, because we haven't it hasn't come up yet. And one of the issues in Vavilov is the standard of review of constitutional issues. And in Vavilov, the correctness categories that are preserved in Vavilov are pretty narrow. They're based on the rule of law, but it's not the rule of law as we necessarily know and love it. It's a very limited conception of the rule of law, which is engaged where there is a need for the courts, the superior courts, to provide a final definitive answer. And that means, maybe a facial challenge to the constitutionality of a statute will attract correctness review, but not everything constitutional will attract reasonableness review and will attract correctness review. And in fact, when the question is, was the charter or another constitutional provision violated in a particular case, reasonableness will remain the standard of review. That's the starting point, but the duty to consult might be an area which is a little bit more nuanced.
It is. It is, because when you looked at exactly the words that the court uses in Vavilov for the exception related to constitutional questions, it's paragraph 55. It gives example of constitutional questions that would be subject to correctness. And so the court says questions regarding the division of powers between parliament and the provinces, the relationship between legislature and the other branches of the state, the scope of Aboriginal and treaty rights under Section 35 of the Constitution Act, and other constitutional matters. And the question is, where do you classify or categorize the duty to consult? Because the duty to consult is not synonymous to Aboriginal and treaty right under Section 35, which is something else, because the duty to consult has arisen from an interpretation of the Supreme Court of Article or Section 18 of the Indian Act. And therefore, it means that if it's not qualified as Aboriginal and treaty rights. Are the traditional approach that was applied to the duty to consult maintained or not? Because in the past, well, pre-Vavilov, the question of the triggering of the duty to consult was subject to correctness, whereas the application of the duty to consult was subject to reasonableness. So if you consider the duty to consult as being equivalent to Aboriginal and treaty rights under Section 35, it means the scope is still reviewed with the correctness standard, because it's the way it's worded by the Supreme Court in Vavilov. And the question of the application remains reasonableness. And it's how it's been applied so far by the, notably by the Federal Court of Appeal in the Coldwater First Nation case, which you might have heard about because it's the case where Indigenous communities are challenging the second approval of the Trans Mountain Pipeline project authorization on the grounds that the Crown's continually failed to fulfill its duty to consult. And in that case, the court said that it classified the duty to consult as pertaining to the category of the scope of Aboriginal rights under Section 35 and applied the pre-Vavilov approach. So triggering is correctness and application is reasonableness. But there is an argument, I think, that would mean that, that could be made to classify the duty to consult as other constitutional matters, as it's not, I think, equivalent to rights protected under Section 35, which means that both the triggering and the application of the duty to consult would be subject to correctness. And when you think about it, it would make sense, because what the Supreme Court says in Vavilov is that, for example, federalism questions requires to be reviewed on the higher standard to ensure the integrity of the constitutional order and legitimacy of constitutional rule. And the adequacy of consultation, I believe, raises the same concerns, which means that current framework should be reconsidered in favor of correctness standard for both steps of the application of the duty to consult. And there's an interesting blog post on this on the All blog, so I think it would be interesting for people who have interest.
Yeah, I put the link to that blog by Howie Kisowitz and Robert Hamilton in the chat. For what it's worth, I think the better route to away from reasonableness review in respect of the duty to consult is to say that it's procedural in nature and doesn't relate to the merits of the matter. So it doesn't engage with the Vavilov framework at all. It's more of a Baker type assessment. That would be my if I wanted to get to where you, Howie, and Robert want to get to. I think I'd do that. And to tie back to Stefan Bolak's question from earlier, maybe that's a question for season 2 of Vavilov and procedural review. I want to swing back to Christy and talk about this issue of trust, which Stephanie raised. Who do we trust? And it's a theme which runs through all of the comments you've made. Who do we trust? Do we trust regulators? Do we trust the courts? And in the area of economic regulation, what's the answer, Christy? What should the answer be?
Yes, well, I'm not sure there is one simple or single answer, because I really heard what Stephanie said about the possibility that in the environmental context, regulators can sometimes see the public interest as being equivalent to economic interest, and that for that reason we need courts to oversee. And I think that's fascinating, because in my world in securities regulation, I don't actually have a great deal of faith in generalist courts to oversee securities regulation. I'm not, for example, cheered by the Supreme Court of Canada's decisions on the prospects for a national or cooperative securities regulator, which I think, well, they're not, I'm not cheered by them. I do respect the expertise of a tribunal like the Competition Tribunal, which comprises economists and judges in different quantities based on different kinds of questions. But I think there is some meaningful expertise there, which is different from a generalist court. And if you care about things like anti-competitive activity, then I think it's important to have that economic expertise involved. But I guess I'd also say there's a cognitive capture piece that I worry about when it comes to generalist courts. So if you're a securities
Well, Christy has cut out just as it was getting good. The internet out in BC abandons us. I was wondering again on this issue of trust and on this issue of expertise. Maybe Jamie and Steve, the answer to maybe the answer to the question that I'm posing is that in areas of securities regulations, say, or in labor relations, there is a relevant expertise that a decision maker has over the courts. But maybe, Jamie, I suppose you did say this, that in terms of expertise, your average decision maker in the refugee protection division, or even at the refugee appeal division, maybe doesn't have any special expertise in statutory interpretation, or may not even, aside from issues maybe of addressing credibility, maybe doesn't have any specialized expertise. A judge is equally capable of looking at the record, looking at the papers, and coming to a conclusion on whether the person's a genuine refugee claimant or not. And that kind of ties into one of the questions that came up in the Q&A. It's from Professor Stacey. Everyone's up early in Vancouver today. Jocelyn asks what Vavilov might mean for the role of international law in judicial review, and that's particularly important in the immigration context, of course. Steve, I don't know if you want to jump in there and say something, and then I'll let Jamie answer the question I posed to her.
I'm happy to defer to Jamie first, and if I have anything to add, I will.
So I would just say that, yeah, I mean, I think, the first question is, what are we talking about when we talk about expertise? And as you pointed out, Paul, that are we talking about statutory interpretation in terms of expertise in interpreting law? Are we talking about expertise when it comes to evaluating whether someone is telling the truth or not? Are we talking about expertise in terms of, how to decide whether one fits within a particular definition of refugee? So there's like different ways of interpreting what expertise is. And you're right, when I was speaking in terms of Vavilov, some of the issues that some of us have in the bar, in the immigration bar, is that some of the decision makers are interpreting provisions in wildly different ways. And, there are, cases where they're completely opposite to one another. And we're seeing this divergent play out in the lower courts and judicial review as well, when they're tackling on whether or not a decision is reasonable now in terms of interpreting a particular provision. So I would say in the realm of statutory interpretation, where it is involving some legal expertise, some attribution to our other obligations under international law, there, our preference would be to have the courts play a more active role so that there is one true answer applied to particular cases that provide clarity in line with our obligations. And so that's, I think, it does follow the reasoning in Vavilov on that sense, but it also, I think is in Vavilov, I think this is an opportunity in order to question, what is the true role of the courts when it comes to this kind of role, especially in cases where we feel that, expertise is not quite what we think it is, if we're to examine it from that standpoint.
So if I could, are you going to let me add something?
Go ahead. Yeah, sure.
Yeah. So I think it was Professor Diesenhaus who said that expertise is the substantive rationale for deference. And so I think despite what the court has said in Vavilov, one can't help but wrestle with this question of expertise in considering both the appropriateness of deference and the degree of deference. The awkwardness is, and I don't have an answer to this, that the courts don't want to be in the game of determining whether a particular immigration and refugee tribunal has expertise or doesn't have expertise, whereas a particular labor tribunal does. And I've no one, to the best of my knowledge, has come up with an answer to that dilemma. And I think that may be in part what drove the court in Vavilov to reject expertise. But I don't know that that's a satisfactory resolution, because, and I also think another factor that the court didn't take into account that I think is really critical is independence of the tribunal. I don't understand how deference is appropriate where the decision maker has no independence, and that isn't the factor that the court gave any weight to. So I don't know that we've heard the last. It may not be 10 years, but I have a sense that these issues are with us for eternity.
But in a sense, they did resolve the debates about expertise and the metaphysics of expertise in Vavilov by saying that what matters is the demonstrated expertise of a decision maker. I don't know what that means.
I have no idea. Yeah, I have no idea what that means either, because I don't know how one. It seems a bit. Who gets to decide whether the expertise has been demonstrated is the reviewing court. So I don't think that's the right place for expertise. I think expertise explains deference, or at least it's one of the key factors explaining deference. And I think in losing sight of that, I think the court made a wrong turn.
Yeah, well, I suppose demonstrated expertise might be one of those things which you only know when you see it, which may not be very helpful. Christy, you were making a brilliant point and were cruelly cut off by your Wi-Fi, and we'll have the CRTC look into that. But a couple, so just one question in the Q&A to throw at you. So first of all, I should say that Gareth Morley from the AGBC's office and Michael Morris from the Attorney General of Canada both responded to the point in the earlier panel about whether there was a legislative perspective in the Vavilov hearings, and they both suggest that there was, that governments, the AGs, were capable of taking a sufficiently broad view. And then Gareth asks, in respect of this panel, how legislatures should respond in areas where there are statutory rights of appeal. And so if there is a concern, Christy, that there will be insufficient deference to expert decision makers who deserve our trust, should legislatures respond by trying to provide for more deferential review? And is that a realistic proposition?
Well, I mean, I think as many people will know, in BC, we have the Administrative Tribunals Act, which does prescribe statutory standards of review for judicial review. And it's out of date. We still have the statutory standard of patent unreasonableness from pre-Dunsmuir. I think there hasn't been energy around revising the ATA until after Vavilov. And so one of the consequences of Vavilov may be that I'm seeing renewed pressure to, for example, get rid of patent unreasonableness once and for all. And certainly when it comes to an economic tribunal like the Securities Commission, which is provincial and would be subject to the ATA, I think it would be helpful to see not only a re-evaluation of whether we still need patent unreasonableness, but potentially a reassessment of what the standards of review on judicial review should be, and maybe broadly with respect to particular tribunals. So for example, amending the Securities Act in response to this incursion.
All right. Thank you very much for that, Christy, and thanks to all of you, Steve, Stephanie, Jamie, and Christy, for engaging with me in a very detailed and fruitful discussion of various areas of life after Vavilov: economic regulation, labor law, immigration law, and environmental law. I'm not sure we came to any firm conclusions about the questions I posed at the outset, but sometimes it's the journey rather than the destination which is important. And so we'll take another break now for 10 to 15 minutes before coming back with our third panel to look at the effects Vavilov might have on administrative decision making on the front lines, in administrative tribunals, and on the bench. So thank you all again, and see you shortly.
Hi guys, how are you?
Good. Nice to see you, Angus.
Nice to see you, Jennifer, and to meet you, Jennifer Rasso.
Another Jennifer.
Nice to meet you.
Okay, hello again, everybody, and thank you for tuning in. This is the last panel of the day, panel number 3, where we're going to take a look at the implications of Vavilov for particular areas of administrative decision making. What is it that Vavilov is going to do in respect of the actual making of decisions? And that's a question which poses itself everywhere, from the front lines of public administration to the judiciary. And the issue, I suppose, is that Vavilov talks a lot about the importance of a culture of justification in administrative decision making and in the reasons for administrative decisions. But that leads to the question of how influential Vavilov is actually going to be on the ground. And it is to that issue that our attentions will be directed in this panel. I'm joined by Professor Jennifer Rasso from the University of Alberta, Jennifer Curana, the Vice Chair of the Canadian Human Rights Tribunal, Angus Grant from the Immigration and Refugee Board, and Mr. Justice Alexander Pless from the Superior Court of Quebec. Jen, I'm going to start with you. Now, you've written some brilliant work on frontline decision makers in public administration, and you suggest that the conventional view that lawyers have about reasons for decisions and the functions and purposes they serve are misplaced. And so I wonder, all this emphasis in Vavilov on the importance of justifying decisions to those affected, what is it that Vavilov is going to do on the front lines of public administration?
Well, that's a great question, Paul. And so thanks for having me as a participant in today's discussion. And I'm joining you today from Treaty 6 territory and the Métis Nation homeland in what is right now pretty sunny Edmonton, Alberta. I think this question is a really good one, asking what the impact of Vavilov might be on the front lines, and especially building on some of the comments that Jamie was making in the previous panel. Frontline contexts are quite widespread. We might think of them as really the most common place where individuals in Canada and even outside of Canada, as Mr. Vavilov experienced, come into contact with state officials. It's how they, it's a primary place where they and where we experience what the state is, how government functions, and so on. Yet, of course, frontline decision makers very often are not the key players in judicial review decisions. Typically, judicial review decisions in administrative law focus on adjudicative tribunals, other types of regulatory bodies like the CRTC, and so on. But I think that it's important to reflect on the impact that Vavilov may or may not have in frontline contexts, because they do play such an important role for all of our experience of state power and the exercise of state power. So thinking about what frontline contexts are, I think first is important to try and frame the discussion. Of course, frontline contexts exist at borders, in those admissions decisions or in frontline officials' evaluations of individuals' requests to launch a refugee claim, as Jamie noted in her presentation. But frontline officials are also widespread in a number of other contexts. We can think of the role that officials have in child welfare programs, for example, deciding whether intervention is needed into the lives of different families, and identifying which parents or caregivers are at risk of endangering children. And of course, there's all kinds of complicated assessments that go into that type of work with dire outcomes one way or another for children and for families. We can think of social assistance decision-making, which is where my research centers on, where we have quite a number of different frontline workers, case managers, and so on, evaluating people's circumstances, trying to make sense of complicated legislative schemes, and then ultimately coming up with decisions about eligibility for a wide range of benefits and other types of supports. We might also think of the Canada Revenue Agency as a frontline context, one that we're very likely all familiar with. Even though we may not actually see the front lines ourselves, they may be represented to us on a web page or in a letter that we received from the CRA, for those of us who aren't doing everything online these days. But certainly that's another area where we have very basic decisions made about individuals' income tax filings, and increasingly the types of access that individuals have to different types of support programs that are offered through income tax infrastructures. So we might think of the front lines as having common features. Of course, as has been noted in the discussions today, the expertise of frontline decision makers or frontline officials varies. And while frontline officials may not be expert in the Rizzo-Shoes doctrine of statutory interpretation, they often do have a certain type of expertise that's gained from their work within a particular administrative setting, and expertise about how the institution functions, about what policy dictates, and of course that expertise may not sometimes reflect what the policies say on their face, but there's certainly a culture of expertise that comes along with having worked within a particular administrative setting for a number of years. And also expertise in some sense in terms of the types of dilemmas that they face on a day-to-day basis when evaluating claims, and so on. Other common characteristics of frontline settings include what I would describe as having layers of decision makers. And you can see this in the Vavilov set of facts on its own. So while we might anticipate frontline officials existing in a kind of very direct face-to-face interaction with a person who they are hearing from and whose decision they might be, and whose lives they are impacting rather, very often there are many different decision makers within a frontline setting who are having an effect on the outcome that is reached. So for example, in the border crossing setting that Jamie was describing, you might have a face-to-face interaction between a single border official and one person who's claiming refugee status or who's seeking to claim refugee status. But that individual official very likely is thinking of what their colleagues will think about their decision. They very likely have to report to some sort of manager, and all of those officials impact in varying degrees the outcome in that individual relationship between the one official and the person who's seeking refugee application to be made. In addition, we see increasingly the strong influence that a variety of technologies have in these settings. So while I describe frontline settings as a place where we might have face-to-face interactions, very often these settings are places where there is mediating technology or interface that exists between officials and the people who are being influenced by their decisions. So the CRA example I gave is one that many of us may be very familiar with, where the interaction that you have with the Canada Revenue Agency and its frontline officials is mediated through web pages, through phone lines, through various electronic forms, and so on. And some of my work centers on the important role that those mediating technologies play, not just as kind of screens that filter experiences between officials and members of the public, but as decision-making forces themselves. And so how does all of this then translate when we are looking at the impact that Vavilov might have in these types of settings? When we're trying to evaluate the impact of a decision like Vavilov, we might take an empirical approach. So we might look to administrative agencies and get inside, actually consult with folks who are working within the Canada Revenue Agency, who are working within a child welfare agency, for example, and ask them, have they heard of Vavilov? Do they know about the obligation on them to provide a certain type of reasons if they anticipate or if they hope that their decision will be respected and understood to be reasonable if it were ever judicially reviewed. That, of course, requires quite a lot of resources and time to do that research. And some scholars suggest that judicial review decisions, even very monumental decisions like Vavilov, don't actually have much impact on the ground. So we can look to the work of scholars in the United Kingdom, Simon Halliday and Dave Cohen and others, who have actually gone into administrative settings and seen that pretty groundbreaking decisions of UK courts don't have much impact on the ground within administrative agencies in the UK. But we might also reflect on the work of other scholars like the late Rod MacDonald, who suggested, following the Baker decision, that any shift in the requirements that courts might impose on administrators when it comes to reason giving and so on may inspire those administrative officials actually to kind of achieve formal compliance with the requirements while actually obfuscating the real reasons why they may reach their decisions. And so that too might be something that we see in certain frontline contexts. It's unclear. I think one thing to keep in mind is that frontline decisions are not never, but are rarely judicially reviewed for a variety of reasons. Practical reasons come into play. Those who are impacted by frontline decisions may have never heard of judicial review. They may think of human rights tribunals or other forums as the place where they would want to go with their grievance, and not an administrative lawyer who could help them with a judicial review application. So because of that, it may be that judicial review is not the type of incentive or threat that we would see that might motivate any change of behavior on the part of frontline officials and or their managers, who would be responsible perhaps for changing how frontline officials go about doing what they're doing. That being said, I think one of the interesting points to reflect on with the Vavilov judgment and the focus that the majority has on the importance of reasons and the vision I think that the majority has as it describes the types of reasons that might satisfy a reasonableness review. It's interesting to hold that that majority judgment up against what is actually happening within the front lines of many administrative agencies these days. And so to do that, I think we need to take full account of what Mary Liston had described as a kind of neoliberal turn within the administrative state, and what others like Karen Young have called a turn to new public analytics. And by that, I mean looking to the real significant impact that a variety of technologies have on frontline officials as they're going about reaching decisions. And one of those effects that I focus on in my work is the challenges that these technologies pose for anyone, even those within an administrative agency, to be able to easily trace the reasoning of a decision or the reasoning that led to a decision. Certainly, it is difficult enough to trace the reasoning that may have generated an outcome when you only have human officials involved, and perhaps more basic technology like a checklist, let's say, that may have guided those officials. You may have sparse records that exist in a frontline setting as to why an outcome was reached. A letter that might be generated to an individual impacted by a decision may do what Rod McDonald warned of, which is provide some general information about how an outcome was reached, but not actually get into the details of why an outcome was generated. But when you add additional layers of more complex technologies into the mix, for example, case management software where caseworkers write reasons or notes to one another that end up getting buried in the software itself, or where you have more forceful tools like risk assessment tools that generate scores that frontline officials then rely heavily on as they reach a decision, and whose functioning may be quite difficult for both frontline officials and outsiders to understand in terms of how the risk assessment tool generated an output. Then it starts to become even more difficult to understand the reasoning that may have led to an outcome. And so if we read Vavilov as perhaps placing a renewed emphasis on the importance of administrators justifying why they've reached a particular outcome, then the facts on the ground in frontline contexts, I would say, suggest that it might be even more difficult today for frontline officials to satisfy the factors that the court has set out in Vavilov for these reasons. So there is some movement in frontline settings today based on policies that have been introduced at higher levels. So we can think of especially the federal directive on automated decision making, which could be an alternate approach to setting standards or having an impact at the front lines when it comes to supporting and reinforcing the need for well-explained decisions, let's put it that way. However, with policies like that federal directive, one of the challenges that I see, at least taking an administrative law perspective on that directive, is that there's been an adoption of the language of explainability of automated decision-making systems, which is drawn from a quite different frame. So I view it not as necessarily reflecting the kind of justified reasons that administrative law folks might have in mind, but rather thinking about explainable AI, which is more of an approach that requires that those who use automated decision-making systems are able to tell anyone impacted by that decision how that system functions. And you can, I'm sure, quickly realize that the description of how a system functions may not actually be the same thing as legal justification as to why that system interpreted the law a certain way and applied it in a certain way. So while we might look to these new types of policy tools as perhaps a supplement to what the court, what the majority has stated in Vavilov in terms of the importance of reasons, my sense is that these policies actually take quite a different approach to the requirement for reasons, and instead taking that explainability type of approach. And so they may not actually be sufficient as an additional tool with which to reach perhaps some of the outcomes that the majority might want to see from administrative decision makers, if those decision makers are justifying their decisions as reasonable. I'll leave it there because we have many other people who I'm sure want to chime into this conversation. But I look forward to the rest of the discussion, Paul.
Well, thank you very much for that. That's a fascinating overview of this area. I mean, perhaps to some extent, the Supreme Court is like generals fighting the last war. All this talk of justification and responsiveness might have been directed to decision-making practices on the front lines, at least in the previous century, and things have moved on. But as you say, one of the questions is whether new forms of decision-making, especially those relying on or embedding automation, will ever satisfy the requirements of responsiveness and justification that the Supreme Court has set down. And certainly there's some federal court cases which are starting to grapple with the extent to which frontline decision makers can be expected to live up to those standards. But one area which is very much of this century is administrative tribunal decision making. Administrative tribunals don't have the luxury of falling back on technology to render decisions. Administrative tribunals are often in the crosshairs of judicial review judges, and so Jennifer Kirana, you're a tribunal member. You're a leader in your tribunal. How has Vavilov changed things for you and your colleagues in the last year? Is it business as usual or a brave new world?
Thanks very much, Professor Daly, and thanks also for the opportunity to be here. I must confess it's quite daunting, having listened to the other panelists this morning, to follow the likes of you, but I appreciate and thank you for including the perspective of those of us on the ground, as it were, because I think that's a critical part of the discussion. We talk so much about putting the individual at the heart of this and remembering that they're at the center of the decision-making process. And certainly for those of us on the ground, as it were, we see that and feel that every day, and certainly should. And so I guess I would start there in answer to your question that I don't know if this is a popular or unpopular response or answer based on the crowd here today, but I would submit that not much has changed in terms of our day-to-day life. But Vavilov does help support, affirm, confirm best practices in decision writing. And there's aspects that we can celebrate and herald, I think, because they reinforce outcomes that are ultimately good for the parties that we're here to serve, and hence for our broader systems of administrative justice. So to the extent that Vavilov sets the bar, as you said, slightly higher, or, takes a more, ensures that we recall and we remember when we're working that courts will take an exacting, robust look at our reasons, and that reasons first is the approach that should dictate that. It helps to affirm or confirm, I think, the good decision writing practices and training that we should have been following in any case in our respective tribunals. And I know there are probably many adjudicators like me on the line, and if you've had a week anything like mine, it looks something like this, right? You're thinking you're coming up to a holiday break. You've got this ruling to finish. You've got a merits decision in the works. You're, racking your head in the middle of the night trying to think, how do I explain this complex concept in a way that an unrepresented, potentially marginalized, very vulnerable party who's, for whom these issues are deeply important is going to understand in my reasons. How am I going to get, I want to get this done. This decision has to get out. This person who's been waiting in our human rights system years to get a result, that's what keeps you up at night. And I would submit that if that's what you're concerned about, a decision writer, and as a tribunal leader as well, working with and managing members, then you've got it right. Not how do I escape the scrutiny of judicial review, and that in your sort of day-to-day life, the parties at the heart of these disputes are who you're writing for and who you should be writing for and should care about. And that, the clear, good writing you do that's transparent, accessible, intelligible for your ultimate parties will also be good for you on judicial review. So I guess I'll just say that, as examples from my own background, I work in the human rights world, and I heard the other Jennifer talking about frontline work in the social assistance work. That's also one of the tribunals, and social benefits tribunal, that I have a background in. And these are real people with real problems who come, it's not an academic exercise, right? They come to us looking for an answer, and they deserve and have a right to, and we have an obligation to give them an answer in a language that they understand, and to explain our reasons and to be transparent about that. And that, as I say, that's also what I understand should always have been the case in our decisions. And whether it's somebody worrying about, their social assistance, are they going to get evicted from their flat in the dead of winter? They're a person who alleged sexual harassment over a number of years or has been terminated because they were pregnant. They deserve an answer. They need one. And in our context, in the Human Rights Tribunal, 70% or so of complainants are unrepresented. It's not an easy process procedurally to get through in terms of case management, just even getting to a hearing. And so I would suggest that their lives and livelihood and these issues fundamental to them are at stake, in particular based on the power imbalance I know one of your other speakers mentioned as well. So, and that's why I think I appreciated all the more Professor Mullen's opening sort of scenario where he talked about Mr. Vavilov and saying, it's probably cold comfort to a lot of litigants to think that, oh, look, you'll take your place in the pantheon of administrative law, or he phrased it much more eloquently in all ways, but be grateful, maybe you'll win anyway, right? This is cold comfort to the folks that probably Angus and I see every day in our hearings and in administrative tribunals. So what are the best practices individually as a decision writer, or as those who, are engaged in leadership and help to train and work together with members? As I've said, obviously we need to be logical and rational. We always did, to the extent that it puts at the forefront that you have to explain how and why a decision was made, justify your interpretations, be responsive. I think it also helps reinforce the fact that it's kind of out with the traditional way of dumping evidence and facts into a decision and just having these conclusory statements. If you weren't already on board with that as a decision writer, you should be now. So those best practices of clear, concise, accessible, intelligible, responsive reasons are the hallmarks and features of a good decision. They were before, but this certainly helps to reinforce that. And I would say in terms of how you craft and structure decisions as a reason writer, so many tribunals around the country invest heavily in decision writing training. Which is great. There's been a huge transformation. I think it's no question that having that issue-driven structure with integrated reasons, writing for the losing party, that these are all standard practices. If they're not already, this decision I think certainly helps support that. And obviously, explaining your decisions through your reasons, the consistency, why you're departing from an established principle or line of cases. I think by and large, most adjudicators on the ground are trying the best they can. It doesn't always work. We may not always get it right. And yes, members want to survive the court's scrutiny, but I would suggest that shouldn't be what keeps them up at night. And then in terms of, the features of bad decisions, like I said, I think the fact that this helps reinforce that whether you write a 5-page or 50 or 100-page decision and you just sort of summarize or dump in all the facts and submissions of the party, and then you put a nice heading in bold that says reasons, and then you just, you don't explain and you're not transparent about how you arrived at that. We always knew that was not a bad decision, but this certainly, again, I think helps us to reinforce that. No boilerplate decisions, and from certainly the perspective, I guess, and I know Angus will probably talk more about this, from high volume tribunals, it certainly helps us as well to ensure that there's support for the idea that there should be some consistency, and it shouldn't be a random exercise of which adjudicator you happen to fall on. And so to the extent that that helps us also work better in terms of training and building databases and being aware of what each other are doing in those larger contexts, all the better. And I would say, sort of on a final note, because I want to make sure I don't take up too much of our other speakers' time, that I think one line those of us in the administrative justice world who understand kind of why we're here in the public service that we offer, one line from the decision, of course, that we can all be happy about is that we can celebrate that administrative justice is not necessarily judicial justice, and it shouldn't look and feel that way. And I think for anyone who's in the practice of this as a frontline adjudicator, decision maker on the ground, you certainly know that to be the case because of the parties that you see before you and the importance of the decisions that you make to their lives. So I think we would all support that. Sometimes we don't do a great job of that. I think tribunals like to pretend they're judge. Tribunal members wanted to be judges, or they saw them on TV, or they want to be like Monsieur le Juge Kless, who's on the line. But we need to remember who we're here to serve and the public service that we offer. On a final point, I would just say that as both members and counsel who are on the line and decision makers know, being an adjudicator engages a whole host of skills, right, beyond just the final result of writing reasons. And so to the extent that I think it's important, you asked about tribunal leadership and tribunal members, we shouldn't be too obsessively focused only on the end result, which is the reasons themselves and the final document that you get emailed or mailed to you, which is the decision, right? There's the whole process to get there. And if you have to follow and demonstrate your analytical path, you also have to, as a member, as a trainer, as someone who works with members, think about how you get to that path. So to the extent that, decision writing does not start with the day you open the template called decision or reasons for decision, but starts the day you get the file. So how have you framed the issues? How, are you prepared, particularly in our context with so many unrepresented litigants, to walk into a hearing room and know what you're going to ask, how you're going to actively adjudicate? If you walk out and you haven't addressed those things, you didn't even know the issues in dispute or how to frame them, how are you going to demonstrate that path in your reasons? And truly, how will you how will you be able to get to where Vavilov expects us all to get if you haven't started at the very beginning? So I would just suggest that, yes, decision writing training is critical as long as we understand that when we're thinking about reasons, that starts much earlier on in the process, and that there are many necessary precursors to writing good reasons. So I'll stop there because I know you've got other folks here.
Well, thank you very much for that. I take the point that if you were doing a good job before Vavilov, you should still be doing a good job after Vavilov. Point first writing, issue-driven analysis, all of the other best practices we talk about. But as you say at the end, I mean, there's some discussion of this in Vavilov by the majority, that substance and procedure are intertwined. They're inextricably linked in many ways, and one of the ways, as you've very nicely highlighted, is that the process that you follow leading up to a decision is often going to have an impact on the decision, the substance of the decision that you reach. Angus, let me put you on the spot and ask you ask you something which I'm not mischievous enough to ask Jennifer. And in any event, I think it's more apropos in your setting. So you're at the Immigration Refugee Board, and people should know that the Immigration Refugee Board is Canada's largest administrative tribunal. You make 40 to 50,000 determinations every year, 40 to 50,000. On the immigration side, dealing with admissibility to Canada, criminality.
I should say, Paul, I don't personally make 40 to 50,000 decisions a year.
Well, you know, good one. I don't even have a witty riposte to that. It's been a long day. Really high volume decision making. And I was listening to Jennifer Kurana describing the the need to get decisions out and inform people as to their rights and obligations. But in the immigration context, where the volume of claims is so high, there is a real tension. Many would say, including me, there's a real tension between the getting decisions out, getting them done, and letting people know what their status is, versus the quality of the decisions. And Steve Barrett was talking earlier about the 50-paragraph interest arbitration analysis that was the end result of the Scarborough Health Network litigation. And in the immigration context, you can't have 50 paragraphs or 50 pages for every determination if you want to get through those 40 and 50,000 cases. What does one do with a high volume of cases and the exacting standards of responsiveness and justification that the Supreme Court has set out in Vavilov?
Thanks, Paul. That's that is a tall task indeed to answer that question, and it's a tall task I think at the Immigration and Refugee Board we feel every day. Let me first start off by thanking you for the invitation and for organizing this day that has been really spectacularly informative on my part. I've learned an awful lot from all of the speakers, including the two Jennifers who preceded me. It's a sunny day here in Toronto on the traditional lands of the First Nations and Inuit and Métis people who live in this area and on their traditional lands. And so I'll begin by talking about a couple of things, but I think I'll begin with a slightly autobiographical note, because I think it gets a little bit to the dissonance of which you speak. Before I came to the Immigration and Refugee Board, I was a refugee advocate for many years and an academic, and then I came to the Immigration and Refugee Board as an adjudicator, as a member, and now I'm an assistant deputy chairperson, and so I'm now more in a managerial role within the IRB than a specific decision-making role. As you say, the IRB is really quite a massive administrative law tribunal. One of the benefits of being a part of a massive administrative law tribunal is that you have a built-in, empirically, perhaps somewhat dubious sample size of people to whom you can ask questions. And I did just that in the last week or so. I went to a sampling of our decision makers, and I asked them the question that Jennifer Kurana spoke to, which is whether or not Vavilov has had an impact on their decision writing. And about a little under 20% of them said that it had an impact. And then when I asked a follow-up question, which is whether or not it has resulted in their decisions being longer than they had in the past, which I guess you could call a proxy for more justification within that decision, it looks like about 10, 11% of them said that they have started writing longer decisions. So I guess you could look at that in two different ways. One of which would be that on a pretty significant number of decision makers, it's had at least some impact. But that means that, somewhere north of 85% of individuals have said it's had essentially no impact whatsoever. So I think that speaks to Jennifer and Jennifer's points about how these high-level administrative law tomes filter down and trickle down to adjudicators in the work that they do. And I think to also get back to something that Jennifer Corona spoke to, I think the reason why it doesn't have a massive effect is that adjudicators who are doing their job always try to get the correct decision, no matter what the standard of review is. To go back to the oft-used analogy of the dartboard as an analogy for standard of review, and whether or not a reviewing court looks to whether or not the person hit the bullseye in their decision or just hit the dartboard. I think most decision makers try to hit the bullseye. I think they try to make the correct decision, and I think they generally try to justify those decisions through reasons that are adequate to the administrative law context in which they work. That administrative law context, in our case, being large and often quite complex cases. So if the impact on individual adjudicators who are doing their job is minimal, where is the impact? And I think in a big tribunal like ours, that impact really comes in tribunal management and in how as a tribunal, we try to foster consistency in decision making.
Angus,
Yep.
sorry to cut across you before you segue to the Carl case. Someone called Anonymous Attendee asks whether your question, that elicited the 10 to 11% who have changed their practices, was that appeal level adjudicators at the IRB or first instance adjudicators? The person
that was at the appeal level.
Right.
Yeah. Okay. Yeah. It was a very informal. I hope you don't read too much into my statistical analysis. It was a quick survey monkey to the members that I work with specifically to say, hey, let's talk about this. What impact do you think it's have? I wouldn't rely too much on it, but it was kind of interesting for me to look at. I think there were about 40 people who responded to it. So not nothing, but I certainly wouldn't hold it out as a empirically very defensible survey. So as I was saying, I think the real burden for big tribunals falls on tribunal management to try to think through a couple of things. First of all, how to foster consistency in decision making, and how to do that while hold on 1 second. Sorry, everybody. Guys, out of the room. How classic a Zoom moment was that? Sorry, everybody. The bigger impact being on large tribunals as to how to foster consistency in decision-making and to inculcate cultures of justification within the context of those very high decision-writing demands that we put on decision makers. And, you know, I have this discussion with decision makers all the time, speaking to the tension that you referred to, Paul. And the tension works in a couple of ways, because as you say, there is a real rule of law principle to the justice delayed is justice denied principle. And when you have, you know, literally tens of thousands of people in the queue waiting for a decision, and as a refugee advocate previously, I would hear from my clients all the time with the absolute burden of being in limbo and how hard that was psychologically on them. And I feel that. I felt that as an advocate, and I feel it now as a tribunal manager, and that's very real. And I try to impart that on decision makers who are, you know, kind of saying, can we slow down a little bit here? I'm trying my best, but this is too much. At the same time, because of the rights at stake in matters like immigration and refugee law, we can't give short shrift to those rights, and we have to pay them close attention. And in the way that Vavilov talks about responsive justification, I would say that our tribunal falls at the kind of higher end of that obligation to justify our reasons. So that is a dissonance, and it is a tension. I don't shy away from that, but it's one that we try to manage in a number of ways. One of which is, well, I'll speak to a couple of them. So how we do it, I think Jennifer Corona spoke to a number of them. We invest extremely heavily in at the Immigration and Refugee Board in training and professional development, and we try to be at the very cutting edge of intensive, experiential, and and reasons-based professional development programs, and our members go through really an intensive program of training, both at the outset of their appointment and throughout their appointment. And we make it quite explicit that part of that is to create a culture of justification, to try to foster the kind of engagement with the complex legal and factual issues with which we have to engage. We also do it through performance management and quality assurance. The IRB is about to create kind of centers of excellence, quality centers that will not look at the nuts and bolts of the number of decisions we're writing, which is a much easier metric to capture, but at actually tracking quality of decisions. Of course, doing that while respecting the independence of adjudicators is an important challenge. It's one that I think we're navigating reasonably well, but it is an area in which we are putting dedicated resources to try to do that. And this gets to what you had anticipated, Paul, and then there's the issue of guidelines, what in our context we call jurisprudential guides, and other soft law instruments that we use to try to encourage both reasoned justification for decisions, consistency, and efficiency in decision making. So there are a couple of different ways this comes up. At the IRB, there are guidelines in place that help to guide and structure the discretion of decision makers on a variety of more kind of procedurally related topics, such as SOGI related cases. And no, you have to go. You have to go. Sorry about that, everybody.
Well, we've all been heckled by our own children. It's infuriating. They should be much more grateful, shouldn't they?
And you know, truth be told, I have to justify them a little bit. They don't usually do this, but anyway, here we go. So we have guidelines on a variety of themes, including gender-based claims. Claims related to sexual orientation and gender identity, and on various other procedural kinds of approaches. And then we also have jurisprudential guides, which is something that I kind of refer to as not soft law, but soft jurisprudence, which are adjudicative tools that we use to try to foster consistency in decision making. Historically, those have taken a number of different forms. Over the last couple of years, there have been jurisprudential guides that have been more like models of decision-making on particularly complex legal issues. And there have been jurisprudential guides on factual determinations. And it's those ones that have proven to be controversial. And in a decision of the Federal Court of Appeal that just came out recently, and this is an issue that kind of spanned Vavilov. So the issue arose in the first instance before Vavilov was decided, but has now been resolved, at least to this point, by the Federal Court of Appeal after Vavilov. So it's the decision of the Federal Court of Appeal in Carl versus Canada, the Canadian Association of Refugee Lawyers versus Canada. And in that decision, Carl challenged the board's use of jurisprudential guides, which are decisions that we identify as being particularly instructive in one area or the other. And they did it on three basic levels. The first of which was to say that, first of all, the legislative scheme in which we operate does not permit the identification of jurisprudential guides on questions of fact. The second and kind of related argument was that that where you do identify jurisprudential guides on questions of fact, that interferes with the independence of decision makers, who after all are the ones who hear each and every case and are left with making the factual determinations that are important to that decision. And so they say that Carl said in the appeal that violates the principles of independence, and that they were supported by that by decisions such as Consolidated Bathurst and Elliston that certainly permitted discussions on legal issues, but that did not permit discussions amongst board members on factual determinations. And then finally, they suggested that the identifications of one of their jurisprudential guides actually constituted a reasonable apprehension of bias. And that's because they pointed to what they saw as some questionable bases for identifying one of those particular decisions. So the Court of Appeal rejected those arguments. In a pretty strongly worded decision, gave pretty broad latitude to the board to use jurisprudential guides. And I think part of that reasoning was really related to what the court said in Vavilov. The court makes several references to soft law instruments, to guidelines, and to established internal authority and previous decisions of administrative tribunals as helping to frame judicial review around the reasonableness of decisions. And so it certainly endorsed, in some ways tacit and in some ways overt, the use of jurisprudential tools that administrative tribunals have at their disposal. And I'd simply point to paragraphs 131, 93, and 94 of Vavilov for those propositions. The court in Carl at the Federal Court of Appeal certainly referenced the fact that consistency in decision-making should not be reached at the expense of natural justice or by compromising the independence of administrative decision makers. But it also spoke to all of the very laudable principles around consistency that have already been referred to, such as an outcome and a decision should not depend on the identity of the decision maker. So in upholding the board's broad use of these adjudicative tools, it found three things in the main. The first is that the questions of fact addressed in the jurisprudential guides are not unique to a particular claimant. And so in that way, they're different than the situations that were contemplated in Consolidated Bathurst and Alice Dawn. These aren't, this isn't the situation of multiple board members, some of whom have not heard a case, going back and discussing a factual consideration that applies only to those parties, and then coming back and making a decision based on, a multiplicity of views and evaluations of that factual evidence. This is different. This is because in the many thousands of cases that proceed at the Immigration and Refugee Board, the majority of them do so on the basis of a very similar factual record. And that's because the Immigration and Refugee Board actually produces a lot of that factual record in the form of reports on countries. And it's those reports that were relied on in the jurisprudential guide. And the court said, well, relying on a kind of common factual record like that is, in this particular circumstance, okay, and can be the subject matter of a model kind of decision of a jurisprudential guide. The court also distinguished the situation in Consolidated Bathurst and Alice Dawn by speaking to the fact that these jurisprudential guides are not hidden from view. They are published on our website. They are well known to counsel who appear before the board. We do as much to publicize them as possible because of the fact that we do view them as model decisions. And then finally, the court found that regardless of how good the decisions are, the fact of the matter is that board members are free to depart from those jurisprudential guides if they do so. And this is where we cut back to Vavilov, because the kicker here is that they're free to depart from existing jurisprudence or jurisprudential guides of a tribunal, but only insofar as they justify that divergence. And this is where we kind of get into a culture of justification, I think, at the board in some ways, which is I think, to first of all really foster in our members the reality that they are independent decision makers, and that while we may put forward decisions for them to consider, they are in their independence free to diverge from them. But in the interests of coherence, in the interests of consistency, and in the interests of making sure that the refugee claimants who appear before us are likely to get a similar decision based on similar facts, regardless of who the decision maker is, that where they're going to depart, they should explain why they're going to depart. They shouldn't just say that they are departing. They should explain why that is the case. So the court ultimately did uphold the board's use of jurisprudential guides, but it provided, I think, a really important caution to us in doing so, which is to say, because of our particular decision-making context that does involve this common factual record in a lot of different cases, while we can go ahead and issue jurisprudential guides or other adjudicative tools and identify them as model decisions for the sake of fostering consistency, doing so on a factual basis, especially in a decision-making context where the situation in various people's countries of origin can be very dynamic and subject to change. So we can identify these cases on factual issues, but we have to be very nimble in making sure that we address changes that might change that factual record. And the court said that they are fraught with difficulties, and I think we take that to heart, so that going forward, if we do identify these areas where it's important for us to model decision making on certain factual considerations, we'll do so with the utmost of care. And we will certainly be open to revoking those decisions where the factual situation changes. I'll just finish with just a couple of further thoughts about what I see as our role post-Vavilov, but really pre and post-Vavilov, in operationalizing a culture of justification within a very large tribunal like our own. First of all, encouraging consistency and justification for departing from internal precedent, as I've talked about. Second of all, by fostering and deepening expertise based on real evidence-based research, and that's not only familiarity with the jurisprudence, but it's also familiarity with various other considerations, such as in evaluating credibility. What do we know based on social science evidence about what is and what is not a reliable form of credibility analysis? Three more here. First of all, of those, I think, as I said before, I think taking seriously and trying to operationalize this idea of responsive justification in context is one that we've looked at a lot and that I've talked to about members. How, in our particular context, do we have to justify our decisions? How far do we have to go in justifying those decisions? And as Jennifer Corona talked about, like really remembering who the audience is for those decisions, and that it's not, at least first and foremost, the courts who review our decisions, but the refugee claimants who come before our tribunal. Two other things. One way of operationalizing a culture of justification, I think, is by diversifying recruitment, diversifying those members who are on the board, and we're actively addressing that. And that's maybe not like immediately clear in terms of individually justifying a particular decision, but in terms of what many people have talked about, creating an administrative law tribunal that looks a lot like the people who come before it, I think is writ large an important justificatory piece. And then finally, evaluating judicial oversight and the whole idea of deference and respect being a two-way street. So where our decisions are overturned, even though we're dealing with thousands of decisions a year, and it's hard to go back to decisions that have been overturned, and for individual members to look at the reasons why those decisions might have been overturned, it's important. It's important as a piece to the justification, the culture of justification, I think, and as a whole kind of continuation of this dialogue between administrative tribunals and the courts that review their decisions. So that's all. Sorry for the interruptions along the way. Kind of threw me off a little bit, but thanks to everyone.
Well, we've all been there, Angus. I'm tempted to say at this point that the major theme of this panel has been the irrelevance of Vavilov. So it doesn't matter on the front lines. It doesn't make a difference to good administrative tribunals, and it's really, as your closing remarks suggest there, it's really just scratching the surface in terms of what justification and responsive justification really mean. There's a lot that happens in an administrative tribunal before anyone sits down to write a decision. It depends. You have to recruit the people. You have to recruit the right people. You have to train them. And then after that, you have to keep training them. And it's an ongoing process rather than one which is memorialized at a particular point in time. Anyway, on we go. Mr. Justice Pless from the Superior Court of Quebec. It's not fair for me to ask you, Alexander, whether Vavilov has made a difference to writing judicial decisions, because you haven't had a judicial review matter yet, as far as I can tell. But you were for many years a practitioner, so someone who defended administrative decisions for the government, and perhaps occasionally attacked a few as well. And the question then, from someone who is a practitioner, who litigates, who has to decide cases, or has to write reasons for decision, is Vavilov a better and more workable framework than what went before? It might be irrelevant to on the front lines or even in administrative tribunals, but it's very relevant to practitioners and judges. So, is it better, do you think, than what went before?
First of all, I want to say thank you very much for inviting me. If others have been intimidated by those who've come before them, I am even more so. And I scratched out several pages of notes when people said things that I had wanted to say, but much better than me. And then a couple of occasions where people made points that showed that something I was going to say was completely wrong. So now I know that the best use of my time will be to be brief. So I'll try to be concise. To answer your question directly right away, I still have a few reflexes of being a litigator. I don't want to say objectively whether Vavilov has made things easier, but it definitely hasn't for me. And it may just be because I'm having trouble adapting to my new role, but I find it very challenging. You're right that I haven't released a decision yet where I've applied Vavilov, but I do have one under reserve right now. And actually, I'll just segue from that into a more general observation. I did practice my whole career. I was counsel for the Attorney General of Canada, and I did about equal constitutional law and judicial review, and I teach judicial review as well. And most of my career was defending administrative decisions. I would say Jennifer might think, oh no, I didn't know that they ever defended decisions. I thought they were always against administrative decision makers, but only the Canadian Human Rights Tribunal apparently. Usually we're defending, Canadian Human Rights Tribunal doesn't trust the Attorney General and hires their own counsel to defend them in the federal court. But normally we defend administrative decision makers. And I wouldn't, this is a general observation, I'm astonished by my own lack of imagination of what it's like to be a decision maker. So in some respects, I think of myself just like the other people on this panel. I know I have a different role that I'll probably ease into and have different things to say in a few years about. But the thing that is really amazing for me is that I am a decision maker now, and I would have thought that in my previous role, I would have some sense of what that was like, but I didn't at all. And so maybe it's me, a total lack of imagination, or maybe it really is impossible to put yourself in the shoes of a decision maker without having tried to do it. And Paul, I know you're also a decision maker. And you gave me a little bit of some wisdom and some wit as usual. And a couple of things that I wanted to observe. First of all, I think it's probably true of many of the superior courts. The Quebec Superior Court, especially sitting in Montreal, is a very, very high volume court. I've been sitting virtually nonstop since I was appointed October 1st. I've heard several dozen cases. And so now I have a completely different understanding of the pressure to decide. I have that same, like Jennifer emphasized, lying awake at night thinking about the individuals who've come before me and the impact that my decision will have on their lives and the importance of getting it out to them because they're waiting and it's going to matter to them. Angus, that's something I didn't ever really have because as counsel for the Attorney General of Canada, we didn't have clients in the same way that somebody like Angus who represented refugees had, and where the decision was going to literally be one of the most important moments in their lives. I'd like to believe that my ministers cared a lot about the work that I did, but it wasn't the same at all. And the emotional dimension of being a decision maker and the impact you have on people's lives, the need to get it done and to speak to those people directly in a humane way and in an understandable way. And I, I'm a Superior Court judge, and I think a little bit about the Court of Appeal, but I think mostly about the individuals who are before me and the impact that that has on them. And then the challenge of writing reasons, and that's probably my biggest observation that I want to make about Vavilov, is that like many people have observed, Vavilov appears to raise the bar for what are adequate reasons and what needs to be in adequate reasons. I have a couple of different things that I want to say about exactly how Vavilov does that and some of the jurisprudence that's followed in the year since. I'll start by saying that I had always been very I don't know if the right word is impressed, but persuaded by Justice Edwards-Bay's reasons in Baker when she talks about the importance of reasons. And I pulled out paragraph 39 where she says, reasons, it has been argued, foster better decision-making by ensuring that issues and reasoning are well articulated and therefore more carefully thought out. The process of writing reasons for decision by itself may be a guarantee of better decision-making. So that's definitely my experience, that I'm making better decisions by sitting down and writing them. And so I'm especially interested in that requirement because I know for certain that in my career, without pointing to particular cases, I defended decisions with laconic reasons and with reasons that might have been applied to any similar decision because they reflected very little of the specificity of the case. Certain decision makers, not necessarily federal decision makers. I have some examples of decisions that I use in my teaching, which is literally a boilerplate with boxes to tick of the things and a list of considerations, which are the statutory or jurisprudential considerations, and then the outcome. And it seems to me that that's impossible now, with one exception that I'll get to in a minute. It's impossible now that that kind of decision-making could possibly withstand Vavilov. And when Vavilov uses cautious language, I don't think it describes the newly imposed requirement of reasons as a revolution, but it says that it wants to continue and enhance a culture of justification. So I see that as raising the bar. And so the thing that's the most interesting to me as a person teaching and applying a case like Vavilov is, in what respect does it raise the bar? Where are the kinds of decisions that used to be acceptable and now are no longer acceptable? And I think I have a very tough time in the jurisprudence identifying them. I have a very tough time reading and interpreting Vavilov and finding the guidance that I need to know whether or not, or what will be the indicia of unacceptable reasons that they failed to meet this new standard of justification. So one of the things that it seems to me we might expect is, when you look at the actual standard and you think of transparency and internal coherence, I don't think of internal coherence as something that really, as a standard that lends itself to degrees. I don't think you can say, oh, this is more coherent or less coherent. I think you read something and you say it hangs together or it doesn't hang together. It's internally coherent or it doesn't. So then I think of transparency. And, because I spent most of my career as counsel for the Attorney General defending decisions, I probably had, my little shopping list of quotes from the Supreme Court about different ways of defending laconic reasons, not a line-by-line treasure hunt for error, not perfection. You don't need to see every single argument raised. But to me, the most obvious way of operationalizing the demand that the justificatory standard is raised is by increasing the demand of transparency. And to me, that means, or I shouldn't say it means this, but it has two likely candidates. So when the jurisprudence, let's take discretionary decision-making, for example. So a lot of discretionary decision-making, especially in a context of high volume decision-making, has developed a jurisprudence that that sets out a sort of a shopping list of factors to be considered. And I think we could take a number of those areas of law and show that it's been tolerated up until now that the decision maker mention those considerations and then come to a decision. And I would think that if we are going to take this requirement of justification seriously, that where there is what I would think of as sort of just structured exercise of discretion, where there's either a statutory list of things that needs to be considered, or there's a or there's a number of factors that have been identified in the jurisprudence, we might ask more of the decision maker to be clear in the way in which they consider those factors. How did they influence the decision? So some decision makers are already, I would say, you know, Jennifer and Angus, I'm pretty familiar with the work of their tribunals, and it seems to me that they're very, very good at that, right? They're really, they know the elements of their discretionary decision-making, they know it, and you see it all the time, and it's sort of like for the most part, a best practice in the way to do that. But others, it's much less so, and in different jurisdictions as well that I won't single out now that I'm in this new chair. But really just that habit of listing them and then coming to the decision. So that strikes me as an area that's easily identifiable, where we might hope that the jurisprudence raises the bar, if in fact the intention is to raise the bar. I have a comment about that in a second. And the other area is addressing arguments that were raised before the decision maker. So, you know, the jurisprudence has always said, in both the judicial context and in the administrative context, you know, it's not necessary for the decision maker to address every single last argument that was raised before them. You know, you take this holistic approach, and I would say in the administrative context, the bar is probably has been lower than it is in the criminal context. For example, appellate courts reviewing criminal decisions are more demanding in making sure that every argument is addressed than the federal court in reviewing an administrative decision. But this also strikes me as an area where if we're going to take the requirements of justification seriously, and we have to, and we must articulate areas in which the bar can be raised, then that would be the second one that I would suggest as a candidate. Now, having said that, I've spent some time over the last few months looking at what's going on in the jurisprudence. And Paul, correct me immediately if I'm wrong, but I think that the Supreme Court has only applied Vavilov once in a sort of a substantive way. All of the other occasions are just mentioning it. In fact, I thought it was interesting, they mention it with respect to what it says about the importance of international law. But only in Canada Post do we ever see them telling us what Vavilov says.
This is correct.
Okay, so in Canada Post decision, I feel like we're reading a decision that could easily have been written before Vavilov, in the sense that when they set out applying reasonableness, we get all of the sentences that we're familiar with, and we recognize it's not a long section of Canada Post. I think it's maybe 6 paragraphs, but they go through it, and it really is, you know, I used to write those kinds of things in my factums, like here's what it means to do the reasonableness analysis, and we're seeing most of the other elements, and we're not seeing the court saying, because I know in Vavilov they said we haven't completely changed everything, but I thought that they were raising the bar, and we don't see them emphasizing that they're raising the bar. And that to me was an opportunity to say so, even if they're not gonna, even if they don't hold the decision maker to a higher standard, they could say there is a higher standard. I don't see a ton of jurisprudence where the courts have said it's clearly higher, and now we might have said yes before, but now we can't. And I found one case that I quite liked the reasoning, which was Cowan versus Grand Prairie. It's an Alberta Court of Appeal case. I'll send Paul the reference if you want, where my reading is that the bar is being raised. So so to me, that's the most interesting thing. And now that I'm sitting as a judge who has to actually do judicial review, that's the thing that's the hardest for me. And that's what I'm having the most challenge of is, I used to defend administrative decision makers. I used to know all of the sentences which allowed me to defend less than perfect decisions. And now I have to apply it, and I ask myself, is everything I used to know right, or has something changed? And I feel like the big message, if I take a holistic approach, as the Supreme Court would love me to, in reading their own jurisprudence, I'm reading Vavilov holistically. Holistically, the bar is higher. But when I get into the details of it and I look for in what way is the bar higher, I'm having a lot of difficulty identifying the precise places in which the bar is higher. So I think I promised I was going to be very brief, and now I'm taking just as long as I had initially planned, but less. And so the second big point that I wanted to make is, Paul, you looked like you were going to jump in there. I saw you move your headset.
No, I was, but then you said you had more to say. So
okay,
say
were you hoping I was done? So the other big difference for me, and it's the observation that I had as soon as I read Vavilov, is how regrettable it was that that the court was moving even further away from, and these are points I did cross out a lot of what I had to say that Steve Barrett made earlier, moving away from the role that expertise plays in explaining deference. And Paul, you might remember that I published a paper that I published just late enough so it couldn't possibly be taken into consideration by the court in Vavilov. And like many people who publish papers, you always look in the decisions to see if, maybe they didn't cite it, but could they have read it and maybe they were inspired by it. And I'm confident that if members of the court did read my paper, what they did is they went out of their way to say that it was completely wrong, and that any argument that I thought was remotely persuasive in it was completely wrong. So one of them was to say that whatever we do with judicial review, I don't know what we're going to do with the judicial review, but please let's not forget why we're deferential to administrative decision makers. And I said there's two reasons. One is the importance and efficiency of decision making that's close to people, that's accessible, that the access to justice requirements. And the other is that of the expertise of these decision makers, that they're, I hate that language of the right to be wrong. I actually think that what we should think of is that they're much more likely to be right than a generalist judge. And so that should be central to the justification that we as a society have to why a superior court judge who might have a different view of an administrative decision maker will be deferential towards them. So you could have an efficiency consideration on the one hand, and the other one would be the expertise of those decision makers. And I really believe in that. I worked with a lot of decision makers, and I know that they understand these issues much better than generalists do. And those two things go hand in hand. Sometimes the need for efficiency to get a decision out means that they can't say as much about their expertise because they're making these decisions over and over and over again. And there's things that are very obvious to them and obvious to anybody who understands the subject matter. and don't necessarily get spelled out in every single decision. And so the courts pushing aside the role that expertise has in articulating deference or the reasons for deference, I think is really regrettable. And even after Dunsmuir, I would always say to my students, and I would plead, the way I would plead is, I like to say, sure, we know what the standard of review is, but let's go through the standard of review factors anyway. Let's do the pragmatic and functional test anyway, because to me, those are the elements that give color to the context, to use the language of what, reasonableness is a single standard that takes color from its context. But to me, that's how you color in that deferential stance. And of course, it's common sense, right? That if the decision maker, like Christy was saying earlier, you have these highly technical subject matter like securities regulation, those decision makers have an expertise that generalist judges don't and can't acquire. And the same is certainly true, and I could talk about this for hours, when you think about people who have expertise in areas like social work, making clinical decisions, and then judges come in and have to review them. These are highly expert decisions that generalist judges are often not suited to make. And so the further away we go from having any space in the decision to talk about the expertise of the decision maker, I think the harder it is to apply judicial review in what I think of as a sort of a common sense way. That's what I wanted to talk about in that paper, where I said, what is the justification if you're trying to explain to somebody why a judge who thinks an administrative decision maker is wrong, why they shouldn't intervene? I thought that one of the two big reasons was that administrative decision maker is more likely to be right about this subject. As a community, we want to put the decisions in the hands of people who are the best able to make them. And I just now I've lost track of how much time I spent, but I wanted to point to the fact that in Vavilov, when they do talk about expertise, it says, I think it's paragraph 93, an administrative decision maker may demonstrate through its reasons that a given decision was made by bringing that institutional expertise and experience to bear. In conducting the reasonableness review, judges should be attentive to the application by decision makers of specialized knowledge as demonstrated by their reasons. And what's so interesting about that, and it reminds me, I think it's something that Justice Iacobucci says in Pesum or Southam is that the hallmark of expertise is that you can explain it, that you can explain yourself. But in fact, I think we have to recognize that when expertise is really valuable in decision making, it's when it kind of forms the background of the decision and it allows the decision makers to be more efficient because they know the subject matter so well that they don't have to spell out for the reviewing court every single step along the way that help them to make that decision. So those to me are the two big puzzling areas of Vavilov, which, as I say, to answer your question, Paul, I don't feel like the decision has given a lot of, I feel like in the first respect, I don't feel like it's given a lot of guidance as to how we'll apply a more stringent requirement of justification. And in the second respect, I feel like they've taken tools away from us by not allowing us to be attentive to the actual expertise and experience of decision makers.
Well, thank you very much for that. I suppose, what I would say is that you're right, and Professor Maeda, my colleague Graham Maeda, has made a comment about Canada Post and how there were detailed reasons there. So how much of a difference does Vavilov really make? And that goes back to the discussion, Jennifer's point earlier about good tribunals, continuing to do what they have been doing. And it's areas which are not accustomed to detailed reason giving and detailed reason writing. Some labor relations arbitrators, some frontline decision makers. Those are the areas where the effects, it seems to me, are more likely to be felt. But we won't know that. We won't know if the bar has been raised until the Supreme Court deals with one of these cases, a case involving a ministerial delegate who's hardly given any reasons, a case involving a labor relations decision maker who's hardly given any reasons, a case involving a border officer who's not given very many reasons. And I'm not sure it does look to me like the bar has been raised, but I think you're right to say that it's hard to know in exactly what context that's going to bite.
Can I make a quick observation about this? Vavilov, as a government lawyer, we love the sentence in Baker that nobody's ever pays attention to, which is that says something effective where reasons are required. And we want to always remind the court, it's not always the case that reasons are required. And Vavilov uses that little turn of phrase on a couple of occasions. And it says, paragraph 77, I think it says it is well established that as a matter of procedural fairness, reasons are not always required for administrative decisions. And elsewhere as well, they'll say that. And I've always thought that it's really an unexplored territory of talking about how do you do a sensible judicial review? And this was the other theme of that paper that was absolutely, completely dismissed by the court. How do you do a sensible judicial review if there's no reasons? And that I sort of took that as a starting off point of saying, if you could do a sensible judicial review of a case where there's no reasons, then doesn't that help you support decisions where the reasons are not very good? And what's the difference between cases where reasons are required and reasons aren't required? Is it because it's less important? Is, Loyola, Trinity Western, because of the nature of the context in which the decision was taken, it was taken by a vote of an elected body. The court is very comfortable accepting that there's no reasons for it. Same thing, I think, in Catalyst paper, if I'm not mistaken. So, although in Trinity, they sort of invent reasons by talking about the discussion that had occurred before the vote, even though there was many, many people. And so it's often of open discussion as reasons for a decision. But to me, there's still this space that we don't talk about a lot, which is how you do judicial review of cases where reasons aren't required. And if you did a robust analysis, if some administrative law, a great and influential administrative law professor would write a blog post about that, whether you could, Paul didn't even crack a smile when I said that.
Well, I thought you were talking about Professor Mullen.
Okay. And I didn't know you had a blog. If I had known Professor Mullen had a blog, I wouldn't spend so much time reading yours. But
very good. Well, let me. While you're in full flow there, why don't we pose a question that Professor Geneviève Cartier has posed, and she asks, "Who's the audience for the reasons? The reviewing judge or the individual affected by the decision? And does it affect the way in which we conceive justification?" And I think that's a theme running through this panel. And the answer is that. Jennifer, your answer would be you're writing for the individual, not for the reviewing judge.
And if I can just share, I meant to share this anecdote. I saw that question, and when in the previous tribunal I worked at, the Social Security Tribunal, talk about obtuse legislation to deal with the EI Act. It's probably second to the Income Tax Act, but in one of the appellants called our customer service or 1-800 line at one point, who'd received a decision and said, I received the decision and I don't know whether I won or lost. So what happens? Do I qualify for EI or don't I? So obviously you don't apply for EI unless you've got some challenges to face in your life. So to answer that question very clearly, there's a perfect illustration of what goes wrong when we think too much about judicial review and not enough about answering and providing the service that we're here to do as frontline or adjudicators. That decision was reviewed, I'm sure, was written by a very, a serious adjudicator. It was reviewed by brilliant lawyers and legal services. It may well have held up on judicial scrutiny. It checked all those boxes potentially. But how was it communicated? Was it in a language that person understood? Clearly not. So to my mind, that is a big fail for the administrative justice community and not a victory. So yeah, yes, you have to write for everybody, but why do we exist? We don't exist just for some exercise in our own, displays of cleverness, right? We're here for the individuals who call and ask those questions.
Can I make one quick observation? That is to say that and I want to recognize how, I'm so naive in what this role is like, but my perception is that writing for the person is a higher standard than writing for the reviewing court. That's the case. If you're writing for that person, they should see the arguments that they raised addressed, and in a way that it doesn't require somebody who understands the law already to read. So I would have thought that writing for the person is the most demanding obligation that we have, because you write in plain language, which doesn't allow you to kind of hide behind your legalese. You write in plain language and you address, all the arguments. Whereas when you're doing it for the court, it's like, well, we can all see why that argument doesn't make any sense. So we don't have to, it doesn't really have to be addressed. And, they focused on the most interesting one if you know what's going on in the law. And so maybe I'm wrong about that, but I would have thought, Genevieve is asking who you're writing for. I think it's about, I have zero experience in, one case in judicial review. But I do think it's like, how did the person feel when they received this? Did they feel like, and I feel like I have the exact same duty as a judge to write to the person. Did they feel like I listened to them, that I took them seriously, do they know, like, the issue that I failed to address, is it because I forgot about it or because I didn't think it was serious? It should be there on the paper.
Yeah, I would obviously totally agree, right? They have to see themselves in it, and it is harder because it's a lot easier for us to just regurgitate the bubble language that we all use amongst ourselves than to make good writing good for the person who needs and deserves that answer.
And
Angus, be very quick, please.
I'll be super quick. I think the challenge in that comes in how you do that while simultaneously demonstrating to the court that you actually have absorbed and considered all of the legal complexities that they are looking for on judicial review to have checked off in the realm of justification. Doing that in the plain language and often really the kind of like more outcome oriented way that participants look for is something that I think is a big challenge.
Professor Razo, if you've been sitting patiently, listening to the other discussion, if I just wanted to give you an opportunity to have the last word. I know there are some questions in the Q&A, and I'm sorry, folks, that I'm not going to be able to get to them, and I'm failing in my duty of responsive justification to your questions. But Professor Razo, any concluding thoughts?
Yeah, well, I guess just adding on to what others have just said, I think that this question about justification and who your audience is built into the heart of the culture of justification. I think as it was described and developed by David Eisenhower, that justification is something that is required to individuals whose rights will be impacted by a decision. But of course, administrative officials need to be thinking about justifying their use of authority to other branches of government, specifically the judiciary, as they're exercising authority, so that they have some constraints placed on how they go about exercising that authority. And while, of course, in adjudicative tribunals where you are writing reasons for individuals and giving a lot of thought to how those reasons are formed, this might be something that happens much more regularly. I think there's still a role at the front lines for this type of justification. I'm speaking to a wider range of audiences to occur. I guess the question now is how does that occur at any kind of practical level, especially when you have the increased use of assistive or automated types of decision-making tools that might write the reasons for you through different software programs. And I think that there's a lot of exploration, fruitful exploration to be done on that front.
All right. Well, thank you very much, Jennifer, and thank you as well to Alexander, Angus, and Jennifer, and thank you to all the other panelists throughout the day who've contributed to a very enriching and enlightening discussion of Vavilov 1 year on. Thanks as well to the Center for Public Law for its logistical support, and also the Alex Trebek Forum for Dialogue for its support. One correspondent did get in touch with me and questioned whether I'd ever actually watched Jeopardy, because of course in Jeopardy, what is Vavilov is not the question, it is the answer. And so the question has to be something like, what gives administrative lawyers the excuse to spend a whole day talking about responsive justification and reasons and reasonableness? And then, well, Alex, what is Vavilov? Thank you all very much. It's been a pleasure and a privilege to host you today. I wish you all the best for the holiday season, and let's hope 2021 is a little bit more appealing a year than 2020 has been. So good luck and